I would now like to call on the Chair of the Assembly, Ms Justice Lafoy, to begin our public session and deliver her opening address.
Well, Móra Íomh a chóide, agus fáilte roimh ar maidin chuig an céad cruinniú den Thionól Saoránach. Is mian lam fáilte ar le a chur raibh an nóchaní ball den Thionól. Those of you who were here earlier, to you I say again, good morning. And to those who weren't here earlier, I say good morning. And to everyone I say welcome to the first meeting of the Citizens' Assembly. A particular welcome to my 99 fellow members who have travelled from all corners of the country to be here today. At what is fast becoming the busiest time of the year as we approach the festive season, I'm very grateful that you've chosen to attend what is the beginning of a very important exercise. You have come from all across the country to be here, giving your free time freely in the service of the state, and I hope you will take some fulfilment and satisfaction in this expression of civic duty, and I genuinely mean that. I also wish to extend a special welcome to those of you who are tuning in online. Fáilte Arís. All of the Assembly's public proceedings will be streamed on our website, and the proceedings are being streamed on 3 separate channels in English, Oscailga, and with Irish Sign Language. I would like to take the opportunity to thank the management and the staff of this venue, the Grand Hotel in Malahide, which will be our base for the duration of the Assembly's lifespan. I know that Matt Ryan and his team have done a great job in preparing the facilities to meet our needs. As you can see, we have all been made feel very welcome here, and I'm sure the members echo my sentiments on that. We're all here this morning because the Houses of the Oireachtas passed a resolution approving the establishment of the Assembly to consider 5 discrete topics: the 8th Amendment of the Constitution, how we best respond to challenges and opportunities of an ageing population, fixed-term parliaments, the manner in which referenda are held, and how the state can make Ireland a leader in tackling climate change. Under the resolution, that's the resolution of the Oireachtas, the Assembly will first consider, make recommendations and report to the Houses of the Oireachtas on the 8th Amendment of the Constitution. And at the risk of wearying you, I just want to emphasise once again, our report goes to the Houses of the Oireachtas, not to the government. The Assembly will then consider, make recommendations and report on each remaining matter as soon as it has completed its deliberations on each matter. And as you know, we have a year in which to complete our task. Well, in relation to today's work, today we begin considering arguably the most difficult topic, the 8th Amendment of the Constitution. I have reflected on the arguably, and I think it would have been more correct to say definitely. It is definitely the most difficult topic we have to address. In 1983, the 8th Amendment introduced Article 40, Section 3, Subsection 3 into the Constitution, which acknowledged the right to life of the unborn with due regard to the equal right to the life of the mother. One of the most fundamental aspects of the amendment is that it was introduced by the people in a referendum, which, as I'm sure you all know, is the only way in which the Constitution, Von Rothnaheran, can be changed. The Constitution is the foundation of our legal system. Under the Constitution, the people are sovereign. The people are the ultimate decision makers in terms of what provisions are inserted into or removed from the Constitution, or what changes are made to it. It is important that the 8th Amendment is examined within the wider constitutional framework in which it is situated. In this regard, the separation of powers between the executive, the legislature, and the judiciary must inform our discussions and ultimately our recommendations. Now, I want to say something about approaching our work. in particular this weekend, and how we have decided to approach it. The Eighth Amendment has been the source of much controversy since its enactment. It is a complex, contentious issue which requires reasoned, sensible and compassionate approach. There are many, many aspects to this topic which will require our attention over the coming months. In structuring the programme for this weekend, however, I felt it was very important that our considerations are grounded in the current state of the law on the Eighth Amendment and the factual situation which exists on the ground in Ireland today concerning termination of pregnancy. And I want to emphasise that at this point, and what I'm emphasising is at this point, we will not be hearing any comments or observations on or criticisms of the current regime. Perceived advantages and disadvantages of the law as it stands and any potential changes to it will be presented in subsequent weekends when we consider the topic. The objective today is to give the members an overview, as I've said, of the law and the application of the law in the medical sphere. This morning we will hear from Dr. Owen Carolan about the current law, and you see the title of his address in your papers. Professor Carolan will explain how the law has evolved from before 1983 up to and including the Protection of Life During Pregnancy Act 2013, which from here on in I'm just going to call the Act of 2013. This afternoon we will have two sessions on current practice in Ireland. First, we will hear how the legal position is reflected in the medical sphere on a day-to-day basis, including how the Act of 2013 operates in practice. Professor John Higgins from Cork University Maternity Hospital and Professor Anthony McCarthy from the National Maternity Hospital, Holles Street, Dublin, will provide us with these insights from the medical profession's perspective. Secondly, Janice Donlan from the HSE Crisis Pregnancy Programme will provide us with information as to what happens on the ground. The existing constitutional rights to information and travel will be looked at. We will also be given some statistics around the numbers and demographics of women seeking terminations. Finally, Dr. Brendan O'Shea from the Irish College of General Practitioners will give us insights into the experiences of members of the Irish College of General Practitioners supporting women with crisis pregnancy in Ireland in the context of the Eighth Amendment. Now, to complement our consideration of the current legal position and how it applies in practice, I felt it was appropriate to consider why ethics is important in the discussion of this topic. Tomorrow morning we will be given an introduction to ethics by Dr. Mark Sheehan from Oxford University. The information to be provided by Dr. Sheehan will allow the Assembly members to develop a way of thinking about complex issues which have distinct moral implications. I would like to take this opportunity to thank each of the speakers who has agreed to present this weekend and share his or her knowledge and expertise. Some have travelled long distances to be with us, and I'm most grateful to them. I would also like to thank the expert advisory group established pursuant to the resolution of both houses of the Oireachtas to assist the work of the Assembly in terms of preparing information and advice this is my choice of adjective, for the invaluable help given by them to me and to the Secretariat over the past 2 months. The help has been invaluable. Now, just a few words about deliberative democracy, because that is what this process is intended to be. All the presentations which we will hear will be supplemented with private roundtable discussions which will provide the opportunity to reflect and discuss what we have heard. Deliberation is a cornerstone of this exercise, and we endeavour to ensure adequate time for this to occur across the weekend. Each roundtable discussion will be followed by a question and answer session. You, the members, will be assisted during the roundtable discussions and question and answer sessions by facilitators who will be accompanied by note takers. I would like to welcome them to this first meeting of the Assembly. We're also joined today by Professor David Farrell from UCD, who is going to be supervising a research element to the proceedings over the coming year in how deliberative the process is, and he's accompanied by Jane Souter, whom I didn't know until this morning would be here, and I welcome both of them. Finally, tomorrow you, and I'm talking to the members, you will deliberate on what issues you wish to discuss as part of your consideration of the 8th Amendment, and this will form the basis of our work programme for the coming meetings, and obviously that is a very important aspect of what we will be doing this weekend. I've already given this considerable thought and have reflected on it with the assistance of the Expert Advisory Group and the Secretariat. It is, however, important that the members themselves can input into the work programme. That engagement will be ongoing. We will need to continue to engage with you to make sure that you are being presented with all of the information you need to make an informed recommendation to the Oireachtas. I just want to say a few brief words about submissions. We are actively seeking submissions from representative groups, citizens' organisations, other interest bodies and members of the public on the topic, the 8th Amendment. There has been a high level of interest in the submissions process, and to date the Assembly Secretariat has received almost 600 submissions from groups and individuals at home and abroad. Submissions can be made online or by post to the Secretariat's office, which is in Parnell Square in Dublin. The submissions are integral to the work of the Assembly, and I would encourage people to have their voices heard, in particular the diaspora and young people under 18 years of age who are not directly represented in the Assembly membership. And again, I think this is important to emphasise at this stage. The submissions will form the basis of the selection of advocacy and other organisations which will make presentations in future weekend sessions in accordance with our rules and procedures. Now, I just want to say briefly about supporting documentation. All of the papers presented this weekend will be posted on the Assembly's website. I'm conscious of the risk of overburdening the members with too much detail this week, but there are 3 other documents going up on the website, and they have been furnished to the members. The first is an outline of the provisions of the Constitution under the heading Fundamental Rights, which I may refer to later. Then there is a chronology of what has happened in the legal scenario since 1983, and how the current state of the law has evolved. It's an outline chronology. It outlines the various matters which have occurred since 1983, for example, decisions of the courts, referenda, reports of committees and expert groups, and the enactment of legislation. And the objective is to give you, the members, the information of what has happened, just in outline. And then finally, and most importantly, there is a third paper which you will have, which was prepared by the Expert Advisory Group, entitled Current Law on Article 40, Section 3, I think this is going to be a very, very useful document. And again, I may refer to this later. I've said a lot. Have I outstayed my welcome? In conclusion, it is evident that this weekend there is very much to do, to hear, to learn, to consider. And again, this is a genuine observation. I'm heartened by the energy and collegial spirit in the room this morning. We will now begin proceedings, and it is my pleasure to introduce Dr. Owen Carolyn from UCD, who is also a practicing barrister and very familiar with what he's going to talk about, to give the Assembly's first presentation. It's on Article 40, Section 3, Subsection 3, and the law on abortion, a history. Thank you.
Thank you very much, Judge Lavoy. What you see on the screen there is the text that was the subject of the 1983 referendum. That was the referendum to insert a new sub-article, Article 40.3.3, into the Constitution, often known as the Eighth Amendment. And you can see there what it says: the state acknowledges the right to life of the unborn, and with due regard to the equal right to life of the mother, guarantees in its laws to respect and, as far as practical, by its laws to defend and vindicate that right. And the paper that's been circulated to you and the talk today, the purpose of those is to give you a brief overview of the relationship between the Constitution and Irish laws on abortion. And there's probably two things to bear in mind at the outset. The first is that's a relationship that to some extent predates the 1983 referendum for reasons that will be explained in the talk and in the paper. And the second is that the question of the precise relationship between the Constitution and the law on abortion is one that has areas of uncertainty, areas of ambiguity. There have been uncertainties, there remain uncertainties about that precise relationship. And again, we'll touch on some of those uncertainties in the course of the next 10 or 15 minutes. So before the 1983 referendum, what was the legal position? There's a number of factors at play here in terms of understanding the position, understanding the public debate that led to the referendum. The first is the law on abortion in Ireland was governed by the Offences Against the Person Act 1861. Now what this did was it created a criminal offence for a woman who intentionally ended her pregnancy, and it also created a criminal offence for persons who assisted her in that process. And that, as you can see, it predated independence, and it was the law from 1861 and was the law when the 1937 Constitution, which is our current Constitution, was brought into force. That 1937 Constitution made no specific references to abortion. So the word abortion didn't appear anywhere in the text, and it was therefore unclear, or there was an ambiguity about the extent to which the Constitution had any implications for the law on abortion. Different judges expressed different views on this. A number of judges suggested, for example, that the right to life in the Constitution extended to the unborn. And if that was correct, that would have implications for example, the ability of the Oireachtas or of the courts to make changes to the 1861 Act. But these were suggestions, and the Supreme Court never gave a definitive view on this question. But that uncertainty formed part of the background to the debate of the 1983 referendum. The other factor that the Supreme Court has suggested fed into that referendum was developments in other countries, and in particular in the law of England and Wales and the law of the United States. And what happened in both those countries was courts gave decisions, the effect of which was to increase the range of situations in which an abortion could legally be carried out. And there were some important similarities in the legal backgrounds in relation to England and Wales. The High Court decision that did that in England was based on the 1861 Act, which was obviously the same legislation that applied in Ireland. In relation to the Supreme Court decision in the United States, that was based in part on the constitutional right to privacy, and the Irish Constitution similarly protects the right to privacy. Now, there was and there remains disagreement about whether an Irish court could or would have reached a similar decision and would have taken a similar approach to the English courts or the American courts. But the belief that an Irish court might do that informed the debate around the possibility or the merits of having a referendum to specifically address this question. And therefore, what did the 1983 referendum do? Well, the first thing it did was it clarified this question. It made clear for the first time in express terms that the right to life did apply to the unborn. What was the effect of this? Well, you can see the effect is summarised there, and these are two quotations that are taken from a Supreme Court decision in 2010 in a case called Roach versus Roach. And you see Mr. Justice Hardiman said the purpose of the article was to prevent the introduction of abortion either by legislation by the Oireachtas or by judicial decision. And Mr. Justice Geoghegan added that nobody could dispute the primary purpose of the referendum was to prevent decriminalisation of abortion without the approval of the people as a whole. And what that indicates is, as Mr. Justice Lafoy has reminded us, the Constitution can only be amended by referendum. So Article 40.3.3, like any other article of the Constitution, is binding on the courts, is binding on the Oireachtas. They're obliged to adhere to it and to remain within its limits until or unless the people decide to change it. So Article 40.3.3 is there and therefore applies to this area, and it would require a referendum if the view was taken it should be changed. And that's what Mr. Justice Geoghegan was referring to in that quotation. So that was the primary effect of Article 40.3.3. But if you recall from the first slide the text of Article 43.3, it's quite general. And it raised more general questions. What are the other effects? What are the general effects aside from this specific question of abortion? And the language of Article 40.3.3 is very broad. It talks about broad concepts like the right to life of the mother, the right to life of the unborn, without giving much more in the way of guidelines or detail about how that operates. That's not unusual for a constitution. Constitutional documents are typically expressed in very general language. They often confirm or speak about broad principles, but don't give much guidance about details. And where there is a lack of clarity or an uncertainty about what that means in practice, it's often dealt with in one of two ways. By legislation, where the Oireachtas provides further details, further guidelines, or the courts may also provide clarification. And in relation to Article 43.3, some of the issues, some of these more general questions that arise or that are left open by the text. Is Article 43.3 only about abortion? The short answer to this is we don't know. Different judges have expressed different views on this issue, but as of yet we don't have a definitive Supreme Court decision or legislation that specifically addresses this, and therefore that, for example, is an area that is somewhat uncertain. What does the unborn mean? Here we have partial clarification on this question. The Supreme Court in that 2010 decision in Roach versus Roach were required to consider whether an embryo that had been fertilised during an IVF process but which hadn't been implanted, whether that was unborn within the meaning of Article 40.3.3. The court decided that it was not, and that gives us some clarification. It suggests that embryos in that situation are not unborn within the meaning of the Constitution, but there may be some other specific situations that there remains some uncertainty about. In relation to the last question you see there on the screen, what does the equal right to life of the mother and the unborn mean? This was an issue arising from the text, where the text talks about the right to life of the unborn and the equal right to life of the mother, but doesn't say anything about what should be done in situations where there may be some tension or some conflict between those rights. And that arose in a decision in 1992, the Attorney General versus X, more commonly known as the X case. And the situation here was a 14-year-old rape victim who'd become pregnant as a result of the rape. The question that arose was whether she, well, a number of issues, whether she was entitled to have an abortion as a matter of Irish law, whether she could travel to have an abortion, or whether Article 40.3.3 prevented and precluded her from taking either of those steps. The High Court found that she was suicidal and there was a risk of suicide from a continuation of the pregnancy. And therefore, the factual situation gave rise to this conflict, where there was a tension between the right to life of the unborn and the right to life of the mother. And what the Supreme Court decided in that case was as follows. They decided that Article 40.3.3 did allow for abortions to be lawfully carried out in certain situations, where under the Constitution, as a matter of probability, it could be established that there's a real and substantial risk to the life as distinct from the health of the mother, and the risk can only be avoided by the termination of the pregnancy. In terms of what constitutes a real and substantial risk, the court accepted that that could be either a risk from a physical condition or a risk from suicide. And therefore, in her situation, she was entitled, as a matter of Irish law and under Article 40.3.3, to have an abortion. These criteria are important because they remain the position at present. So at present, under Article 40.3.3, abortion is constitutionally permissible if those criteria are satisfied. As I say, that's the current position, and therefore that's the position that informs your deliberations in the sessions to come. There are, however, some further developments that you should be aware of in relation to those criteria. The criteria in X about when an abortion may be permissible as a matter of Irish law. There were two referenda, the 12th and the 25th amendments, which suggested changes to those criteria. In particular, they suggested confining the risk to a risk from a physical condition. In other words, the risk from suicide would no longer have been permissible. They were rejected by the people in referenda. There was also, in relation to the X criteria, a question around, again, an ambiguity or a certain lack of clarity. While the Supreme Court had indicated when or what criteria had to be satisfied, there was no further information about how, for example, who made that decision. If a person felt they might come within the criteria, how would they find that out? And therefore it was suggested by a number of the Supreme Court judges in X, and also in the Roach case, that it might be helpful to have legislation on this issue. In 2010, the European Court of Human Rights, in considering three complaints, or complaints from three women about Ireland's abortion laws, found that one of the women, her rights under the European Convention on Human Rights had been breached by this lack of clarity, by the lack of detail and procedure. And in 2013, the Oireachtas passed the Protection of Life During Pregnancy Act, which I understand you'll be hearing a bit more this afternoon, and which basically sets down some more detail about the procedures and the guidelines that regulate the application of the criteria in X. The other developments to bear in mind, following the X case, there were also referenda held on the 13th Amendment and the 14th Amendment. These relate to travel and information. So the 13th Amendment, and these were approved by the people, the 13th Amendment confirms that if a woman is otherwise entitled to travel and to leave the country, she can't be prevented from doing so on the ground that she may have an abortion while she's abroad. And in relation to the 14th Amendment, that confirms the availability of access to information about abortion services in other jurisdictions. And the details of how that works were fleshed out in the 1995 Act. So much like the 2013 Act gives details about the X criteria, the 95 Act gives details about how the rules on access to information work. What that also means is, because the 13th and 14th Amendment have been approved, the text of Article 40.3.3 has changed somewhat. You see, you still have the original 8th Amendment in the first paragraph, but you now have these additional paragraphs that confirm the rules relating to travel and the rules relating to information. And so this is the text as it currently is, and that's therefore also the text that will inform your deliberations today, tomorrow, and over the course of the coming sessions. Thank you.
I'm very grateful to Dr. Carolyn for giving you a very, very clear overview of where we are on the topic we're concerned with. You also have his very, very useful paper, which gives you more detail, and there is a lot of detail in it, and it may be difficult enough for non-lawyers, but I would really ask you to consider that paper, and also to consider the three additional papers which I referred to earlier. There's the last one I referred to is, in a sense, a summary of the current position, and that was prepared by two lawyers in our expert advisory group, Oren Doyle and Rachel Walsh, and that you will find helpful, and I think we'll be referring it to it no more than to Owen's papers in later dates. And then there are the other two, the timeline and so putting the article, the provision, the 8th Amendment that we are concerned with, into the context of fundamental rights. And I brought this. This is the most important document you will have, and what you've been given is the October 2015 edition, which brings it right up to date. So I hope that the appendix that sets out the fundamental rights. I hope that will give you an insight into the entirety of that part of the Constitution. But as I say, this is the important document. Thank you very much. It's now break time, isn't it? Yes. Yeah. And we'll have coffee, and we'll recommence in private for a private session in 15 minutes. So the public session is over, and we're in time. Thanks very much. We did it, didn't we? Sharon.
durch des Himmels prächtigen Land laufen Brüder eure, von laufen Brüder eure, von freudig wie ein Held zum Siegen, wie ein Held zum Siegen laufen Brüder eure,
listening to questions and answers asked directly to Owen. Just there are, I think, about 11 surveys left that haven't been collected, so if you haven't filled it in, if you could fill yours in and just hand them to your facilitators and note takers so that they can be given back to our research team, we'd be very grateful. call on Justice Defoy to reopen the public session.
Very good. I'm now going to open the questions and answer session, and I'm shortly going to invite questions from the floor. But before I do so, I think it's important that I emphasise once again that the questions should be confined to points of information based on the current regime. As I've said previously, the purpose of all our sessions today is to inform ourselves of the current legal position. As such, none of our speakers today will be answering questions on perceived advantages or disadvantages of the law and how it's applied. So bear that in mind. I gather we have a number of roaming mics. Hands up. Yes, yes. And so get the attention of the mic holder if you want to raise a question. So I'll start now by inviting questions from the floor. Yes?
Thank you, Judge. Our table here just would like to raise the issue in regard to fetal abnormalities and say that the legislation doesn't take this into account in any way at this moment in time in regard to what it says. And also that possibly the situation is not in the mother's control. We feel that the table here feels that the mother doesn't have adequate control over the situation. It's really in the medical and legal hands at the moment. I just know how you feel about that.
I don't know whether I'd classify either of those as a legal question or a question on the law at the moment. Of course, the issue of fetal abnormalities is a big issue in this context. I think Owen said in his written paper that it's something we will probably be considering down the road. And that's about all he has said in his paper about it, and that was with our approval. Basically, I think that is a question for another day. In other words, for another of our sessions. It's one of the things you might consider tomorrow morning, whether I think it has to be a matter we will discuss in the remaining weekends. But I think for now, I think we should leave it aside for the moment. And that's not trying to avoid the question. I want to make that absolutely clear. It's just that I don't think it's suitable for today. Would that be your position, Owen?
I think in terms of the current law, as far as I understand it, there really is no clarity on what the current legal position is, and therefore, for the purposes of today, in terms of informing you as to what we can say the law is, that's an issue we just don't know. Yeah,
so that Owen is telling us about the current law. There may be other matters to consider in relation to fetal abnormalities. The second question, situation not in the mother's control. Owen, is there a legal issue there that you can discuss or clarify in this particular context, the context of the current law?
I think adequate control is probably a judgment about the policy, and I don't want to. And it's not my role today to express a view about the merits or demerits of any particular approach. I think you'll be hearing this afternoon from medical people who are involved in the actual process of what happens if someone, if this issue arises in practice. And they may be better able to give you a sense of how a mother is dealt with from that point of view. I mean, from the legal point of view, particularly with the 2013 Act, lawyers don't have much involvement in how we operate so far in practice, so the doctors are probably better placed, I think, to answer or to give you a sense of how that procedure works. Do
you feel that is a sufficient answer pro tem, and I say only pro tem?
Yes, I think it's fine. I think the table here themselves were just interested in other.
The table here, we're just interested in other aspects of this, and as you say, it may well be an issue for tomorrow, but I think it's just probably an opening aspect in regard to people's views here at this moment.
Could I just ask you to clarify, when you say the situation not in the mother's control? What have you in mind?
I think
You're not thinking of somebody of unsound mind or anything like that?
No.
Yeah, I just wanted to clarify
No,
that.
Judge, no, not in regard to that. I think the general feeling here at this table was that the mother didn't have as much input in regard to making the decision
Yes.
as she maybe could or should have.
Well, it may be something that could be addressed after this in
Absolutely.
question in
Absolutely.
the afternoon. Yeah.
Yeah, absolutely. Thank you.
Yeah.
I'm just the facilitator.
Yes.
We have two concerns, or two issues we'd like to seek more information on. The first is the issue of how the procedures actually work, and I know there will be medical, Owen has said there will be medical with speakers, but just in regard to, I suppose, just the general, how the legal procedures are at the moment.
You mean under the 2013 Act?
Yes, and also in particular with some emphasis on the time frame, as in how long does that process actually take to start off and to complete. And then there was a question at the table about the threat to life, whether that's included. And again, it's the current situation where the fetus themselves have some threat to their health or life. And again, it is the fatal fetal abnormalities. If that could be clarified insofar as possible.
Yeah.
I mean, I think I'm reluctant to give you too much guidance in terms of how the procedure works, because to be honest, the law only sets down the framework. It only gives the kind of outer procedures and the outer limits. What actually happens in practice really is something the lawyers don't deal with, it's something the doctors deal with. And I'd be misleading you if I offered you an informed view, because I simply don't. I've never had an involvement in that process. So, and I think you'd be better to get that view after lunch from the people who actually are involved in these processes. They'll be able to answer those questions about what actually happens, because the law simply, let's say, it gives guidelines, but there are areas of discretion within those guidelines in terms of how quickly or how slowly, or it's up to the individual situation of the individual doctors. They may go faster than the law requires, for example. So I think that's something that I think will probably be better dealt with. And as I said, in relation to the fatal fetal abnormalities, in terms of my remit, which is simply telling you what the law currently is, we just don't know what the law is there. And again, it would be misleading for me to give you a statement saying we know this is what the law is. We don't. It's an issue that there are arguments about, there are disagreements about. People have different interpretations of the article. They have different interpretations of, for example, the Roche decision and whether that may have implications for that situation. But we don't have a definitive Supreme Court decision. We don't have a definitive view on it, and we don't have definitive rules on it. And therefore, anything I would say would just be my own judgment, which carries no weight. So, in terms of understanding the current law, all I can say in terms of what's accurate is we just don't know.
Well, again, it seems to me that the first question may arise again in the afternoon. That's in relation to the procedure and the time frame under the Act of 2013. And as I say, the second question, hopefully we'll get to dealing with it at another session.
How are you doing? A question for Owen. The recommendations that will be given at the end, that should be presented at the end, will that be with a view to the wording of the article and the changing of the wording of the article, or just the fact that the article itself can be changed constitutionally?
I think that's probably a judgment for you all to make.
No, I know, but what I mean is that are we looking specifically for text for an article or a change to an article, or just literally just that the article as such, like you said yourself, that it's fairly general, it's not that specific, but that it can be moved about, messed about, or changed? Do you know what I mean? Rather than actual coming up with offers of words, the actual text that will be in a changed article.
Well, I suppose I should really answer that question. That, if I may use the expression, in the heel of the reel, will be a matter for the citizens. We're not anywhere near determining how we're going to make recommendations. We're just getting an overview of the current situation today, and that is something that we will hopefully form a view on in the not too distant future, maybe third meeting maybe, but it's really a matter for us. There are a whole lot of options, as you know, but we will have to decide what way we are going to make recommendations to the Oireachtas. It's for us.
Hello. We would like to ask a few questions in the context of the 3 medical practitioners, 2 of whom must be psychiatrists, to certify that it is necessary to avert a real and substantial risk. Is there statistics available on, given someone has declared that there is a problem due to depression or mental health issues in general, is there a difference between the suicide rates of those that have been admitted into the public mental health system and those that have been admitted into the private mental health system? And also there's another question, how many expected mothers have committed suicide or attempted suicide in recent years? That's the second question. Now, the other, we have one more question.
Can I just say, in relation to that, in fairness, that is not a question.
I understand that.
But it can be repeated in the afternoon when we have people who may be able to answer it.
Okay. And just with a comment on the standing orders and the sequencing of the topics that are to be discussed, we are very concerned about Ireland's environmental responsibilities being placed last in this list, and we are wondering if this can be moved up to maybe become the second or third issue being discussed.
Right. That's the climate change topic.
Yes, the climate change topic. Now, there may be another question or two the facilitator has.
Hello. We have 1 or 2 questions in relation to has anybody been prosecuted in this jurisdiction either for having an abortion or for aiding or helping in one being carried out?
Well, you should qualify that by saying since 1983, I think. There would have been.
Sir, I mean, from the 2013 Act.
Yes, sorry, since 2013.
Since 2013.
Not that I'm aware of. I'm not aware of any prosecution since 2013. There is a report issued, I think it's referenced in the paper, every year, which the Minister lays before the Oireachtas, indicating how many times the Act was used. And on average so far it's been sort of 20 to 30 times per year. But in terms of, I'm not aware of any prosecutions.
Okay, very well. One other question was we had, at what stage or what point does a test tube embryo become described as unborn?
Well, as I say, we have a partial answer to that question from the Roach case. What the Roach case decided was that the embryo pre-implantation, so an embryo that had been obtained during IVF, was not an unborn until such time as it was implanted. And that was largely, I mean, there was various reasons given, but I mean, just probably to give you a sense of the reasoning. You recall Article 43.3 makes reference to the right to life of the unborn and the equal right to life of the mother. And the views expressed by at least some of the Supreme Court that article is about that relationship, but the situation where those two rights are intertwined and engaged, and that only happens after implantation. And therefore the view is taken that there had to be implantation before the unborn before that definition of unborn was met.
Oh, and it might be helpful if you just told the factual background to that case.
Yeah, sorry,
I think it's useful to know what was at issue there.
Yeah, and I think it's important to bear in mind, I think with any of the decisions that you're referred to, whether in my paper or the papers, the courts can only decide the cases that are before them and only decide based on those facts. And therefore there's always an issue where situations are factually different. Where different facts come before the courts, they may give different results because the facts change. So whenever we say a case decides something, really only decide for those parties, or what the law is for that particular factual situation. If you change the facts, the outcome may be different. In terms of the Roach case, the Roach case referred to a couple who had undergone IVF, I think successfully in relation to the first round, and had a child,
Yes.
and subsequently split up. And the question that arose was the mother wished to use the embryos and have further rounds of IVF treatment, and the father refused consent. And there was an initial question about what they'd agreed to in terms of, as a matter of legal contract and the forms they'd signed in the clinic, what they had agreed to. But the second question then was, what about the embryo? Did the embryo have rights under the Constitution? Did Article 40.33 apply to that embryo? And the court concluded that it didn't, for the reasons I've just said in relation to the implantation.
The facilitator for Table 2. We had two questions for Dr. Carolyn on the current legal position. First, if I can ask it, is can EU law impact on Irish law in this area? And some reference was made to the ABC case. And I know you didn't discuss it, but I think it was in some of the papers.
Yeah.
But it would be much appreciated if you could clarify what impact that could have.
Yeah, and that was the European Convention on Human Rights, as distinct from what we would call, what lawyers would call EU law, which would be...
I think it would also be helpful if that was clarified as well.
Yeah.
That's a complicated question, and but it is, I think, it's a good question. It's one that's worth bearing in mind. I mean, the first thing is that point. The European Union law and the European Convention on Human Rights are different, and they're separate, and their status within Irish law is different as well. European Union law automatically applies in Irish courts, and where there's a conflict between Irish law and European Union law will take precedence. The European Convention of Human Rights is a little bit different. The European Convention of Human Rights and the European Court of Human Rights is a different court. It sits in Strasbourg. The European Union Court sits in Luxembourg. So it's important to bear that in mind, that they are completely different courts with different judges in different places. And the European Court of Human Rights, as the name suggests, deals mainly with human rights issues. And it applies what's called the European Convention on Human Rights. And the relationship between that convention and Irish law, there may be some academic disagreement about this, but because as a matter of international law, its decisions are binding on Ireland. But as a matter of Irish law, the Constitution takes precedence. And the European Convention has been incorporated into Irish law. So the Oireachtas passed an act saying this is part of Irish law, but they did so at what's called a sub-constitutional level. So as a matter of Irish law, if there's a conflict between what the Constitution says and what the Convention says, the courts should try as far as possible to reconcile that conflict. But ultimately, if there is a conflict, the Constitution will prevail. Now, A, B, and C, as I've indicated, were three women who made various complaints in relation to Irish abortion laws to the court in Strasbourg, and claimed that it breached various different rights under the convention. The court found in favour of one of the women, and found in favour on that specific issue that I mentioned, the lack of clarity. The court, for example, and this was one of the arguments in the case, the court didn't find that having Article 40.33 was a breach of the European Convention on Human Rights. So one of the arguments made on behalf of the other two women was that simply having Article 40.33 was a breach of their rights. The European Court rejected that on the basis, they said, while other countries in Europe had other rules in this, and the majority of countries may have other rules on it, they felt the Irish constitutional position, having been endorsed by referendum, reflected particular judgments in Ireland, and that didn't breach the convention. Where there was a breach was because the X case said abortion was lawful in certain situations, but there was a lack of clarity and detail and guidance about how that operated. So as I indicated, there was no clear rules about who would you ask, who would make a decision, who made that decision about when X applied, when those criteria were satisfied. The court felt that contravened the person's access to the law. And the European Court takes the view that law should be accessible, it should be foreseeable, people should be able to understand their legal position and take advice on that. And they felt that was where Irish law failed to comply with the requirements of the Convention. And that was followed by the 2013 Act, which seems to do at least some of those things.
Thank you. And the second question is that during your presentation, you posed the question, is Article 40.3.3 only about abortion? So the question arose at this table, what else could it be about, and what other knock-on effects of altering or discussing this could be impacted other than the issue of abortion?
Well, I don't want to speculate, because again, my role is largely about telling you what the law is, but you know, the fatal fetal abnormality issue would have been raised, and you know, that may have implications, potentially, but it's an area where we just don't know. So.
Good afternoon. As facilitator of this group, the 3 questions have arisen. Number 1, under the current law, why did the right relating to risk to the mother not apply in the case of Savina Halabanava? 2, if a woman was pregnant and had cancer, would she have the right to receive treatment if that treatment caused a risk to the life of the child under the current law? And thirdly, conscious of the fact that I may be treading over ground already arisen, what is the unborn, if there's any clarity on that, and when does the unborn precisely become the unborn in a situation not limited to IVF treatment?
Yeah. Well, I think the first question relates to a specific unfortunate event, and I don't think it would be appropriate for anyone to express a view on it here. But do you feel you can sort of give some general observations that?
Yeah, I mean, I think in relation to the first and second question, particularly the second question, and I think it's very difficult, I think, to express concrete views about specific situations without having full knowledge of those situations. And the second question you raised about a person who has cancer, and where that may be a risk, I can't say exactly what would happen because it would depend on the individual person, the cancer, the stage of the pregnancy. You know, there's various things that would be taken into account with that. And that's the 2013 Act is partly about. I mean, all I can say is it would be dealt with under the 2013 Act. And therefore, again, not wanting to put everything into the afternoon and where someone else has to answer the questions. But,
and again, it's something the medics may answer in the afternoon.
You know, you may be able to give you a more concrete view about what would happen in practice when that comes in.
Yeah.
All I can say is it would be dealt with under the 2013 Act, and it would be dealt with in accordance with the criteria and Act. So the assessment would be, is there a real and substantial risk, and whether the criteria are satisfied. And then, I say in relation to the third question, we don't know any more than what the clarification given by the Supreme Court in Roche.
Roche.
I'm the moderator of Table 9. When we discussed the text of the 8th Amendment, we discussed specifically one of the features which I think you had identified as possibly ambiguous, which was the concept of the equal right to life of the mother and the unborn. And the view is expressed at this table that that's an impossible concept, because where two absolutely equal rights are in conflict, how do you decide which prevails? Can you possibly comment on how the courts, and I know you can't comment on medical practice, that was one of the things that was discussed at this table arising from that, but in terms of the courts, how does the law deal with that difficult problem?
It's a very perceptive question, because I think that is the issue that arose in X, is precisely the question you've just framed. When you have two rights expressed to be equal and there's tension between them, what do you do? And I mean, the answer is what the Supreme Court decided in X.
Yeah.
That's how that is dealt with under Irish law, by reference to those criteria.
Hi, it's a question from Table 11. In cases of fatal fetal abnormality where there is no possibility of life outside of the womb, is termination currently permissible under the Act?
I mean, I think the law, we don't have a clear statement of the law on that. Under the Act, it's only permissible if it satisfies the criteria in X. So there would have to be a real substantial risk to the life of the mother.
Okay, and maybe leading on from that is, under the current Act, has a termination in the case of fatal fetal abnormality taken place in the state? And if that is the case, was the decision made by the medical staff or by the courts?
I'm not aware. I mean, because the Act and because the reports on the Act only deal with the grounds in X, Section 7, Section 8, Section 9, that set out the circumstances in which a termination or an abortion is available and is lawful under Irish law. They make no reference to fatal fetal abnormalities, and therefore the reports that indicate how many abortions were carried out under those sections also don't refer to. Now, it's possible there may be an overlap, but certainly there's been no reported case on that specific ground where the reason given was fatal fetal abnormalities. In relation to people travelling abroad, I have no specific information about that. So the law simply just doesn't really have any clear guidelines on that at present.
Hi, I'm the facilitator for table 7. We have 2 questions. The first is in relation to the panel of medical practitioners appointed by the HSE to decide reviews on whether or not an abortion can be performed in any given case. Does the 2013 Act specify any criteria for the election of those panel members, or do they have a limited term? Is there any guidance on who and for how long those people can serve? And the second question is in relation to the relationship between contraception and abortion, particularly stemming from Roach and Roach. Roach and Roach suggests that once an embryo is implanted, it becomes life. And so where would the morning after pill, for instance, come into play, or is there any guidance on that?
Well, Roach certainly doesn't specifically address that question.
No.
And therefore, again, people can speculate about what the implications of Roach might be for that, but as a matter of law, the Supreme Court didn't address that question, and it wasn't specifically raised in the case. So again, it's another area where I think I said at the start of my paper, it's an area where there's a lot of uncertainties in the law here, and Roach doesn't clearly address that. Again, in relation to the 2013 Act, I think it's helpful to have the medical people give advice on that. It does lay down criteria in relation to eligibility, both in relation to people to serve on those panels, and also in relation to who counts the medical practitioner, what qualifications they need to have, whether they need to register the medical council. They are laid down in the legislation, but how they work in practice is something that, I think the doctors are best placed to speak to, because they have experience of that system operating that I just don't have.
Hi, sorry, I just wanted to clarify something. In terms of the Constitution versus the legislation that's in place, is it the case that the reason why there's a lack of clarity and ambiguity in the law, is it because of the wording of the 8th Amendment, or is it because of the existence of it in its entirety? Just you could clarify.
I think it's a good question. I mean, I think, as I mentioned, Article 40.3.3 is broadly expressed, but that's not unusual in constitutional terms. Constitutions generally, I mean, you can point to specific examples in other constitutions. There are constitutions that are different, but as a general rule, constitutions express themselves quite broadly. They're about stating values and stating principles. And what that means in practice, not only in this area but in other areas, are that the Constitution, it really sets the boundaries. It gives guidance to the courts, it gives guidance to the Oireachtas as the kind of things that are important and the kind of things they have to respect and comply with. But there's always a lot of room left for the details to be fleshed out. And I'd say that's typically done through a combination of legislation or decisions of the courts. So legislation will provide details. Courts may be asked then to consider that legislation. On occasions, courts may be asked to assess whether the legislation is unconstitutional, or whether it complies with the Constitution. And that's true of other areas, not simply this one. So in saying there are ambiguities and uncertainties, that's always the case with constitutional law. So it's not, but certainly Article 40.3.3, as I've indicated, there are certain aspects of it that are uncertain, that are ambiguous, but that's typical of other areas of the Constitution as well. And legislation in the courts are typically how that's dealt with. And the 2013 Act is, together with X, together with Roach, gives us some further guidelines as to what it means, but doesn't address all the issues necessarily. And they would be dealt with. People have raised ones here. Legislation cases are ways they could be clarified.
And a provision of the Constitution can't anticipate the large variety of circumstances that may come to pass. We see it as lawyers, we see it all the time. So one has to go a different route probably, like in the X case, it was the Supreme Court or legislation to clarify the situation. But of course, one cannot interfere with the basic principle in the Constitution. Neither the courts nor the Oireachtas can do that. The duty is to apply the provisions of the Constitution. We're getting a little bit tight for time. Are there many more questions? Yeah. The mic has gone behind you.
I'll take that as my cue, so Judge, thank you. I'm a facilitator for table number 10. This is a question about context and climate. And the discussion at this table was, what's different now, today, from 1982 and 1983? And what are the drivers for change? What are those the legal drivers, the prevailing climate, context, and indeed church influence?
I mean, that's partly a question of social history that I'm not qualified to answer. I mean, I was 2 in 1983, so I don't remember it. What I will say is, though, the Supreme, the factors I mentioned are the ones the Supreme Court have identified as being relevant. So in the Roach case, the Supreme Court considered and made reference to the climate in 1983, and certainly the Supreme Court expressed the view that those decisions in England and in America had an impact because they, as I indicated, they were decisions that were based on somewhat similar legal documents or legal principles. And yeah, as I said, there was a disagreement about whether an Irish court would or even could have followed those decisions or taken a similar approach under the then constitution. But the belief that a court might did inform the public debate about, and also just the general uncertainty about whether the 1937 constitution had any implications for this issue. Some judges felt it did. We didn't know for sure, and therefore there was a belief or a view that there was an uncertainty that could be addressed by an amendment. And obviously, different views were expressed as to whether that should be done or the merits. But certainly, the Supreme Court's view seems to have been that it was influenced by developments in other jurisdictions and by the uncertainty of the law at the time.
This would be the last one, I think. Yeah.
The question of children's rights. The question of children's rights. When they're talking about the Constitution, when the arguments are put, they use the whole Constitution. And in any case, children have rights.
Yeah.
Surely the argument point that the children have rights. It's no longer unborn.
Are you talking about the situation in relation to a minor? Is that what a person under 18?
No, the Constitution covers children's rights.
It does.
And people are making the case that the child has rights, and equalising that with the unborn rights.
I mean, I think.
Oh yeah, we're into IRM, I think.
Yeah, I think there have been different views expressed on that.
Yeah.
I think by the High Court at present, and therefore it's again an area where there's some uncertainty about the law and.
Yeah. And an issue has arisen in the very recent past in relation to that, and it looks as if it may go to one of the superior courts to be resolved in the not too distant future. That's my reading of it from reading the newspaper.
Any aspect of the Constitution? You have to take it in total or is it specific?
I mean, as a general matter of interpretation, I mean, leaving aside Article 42A or you're entirely correct. When you look at the Constitution, what the courts have said is you look at it as a whole document, and therefore you don't necessarily just. I mean, obviously, if one article deals specifically with an issue, it's the most relevant, but there may be other parts of the Constitution relevant as well.
Very good. You obviously had a very good discussion at each table. I'm very impressed. The questions are very impressive. Some of them we haven't answered, but they can be raised again. And we'll sit again at 2 o'clock and do some more work. Thank you very much. And thank you.
Thank you. Folge Deine Zauber
I suspect later this year we'll probably get the Keeper of Good Time Award, as we're starting almost on the dot of 2 o'clock. I welcome you all back, and I hope you've had an enjoyable lunch, and that you're ready for this session, which I think is going to be demanding as well, because we had a demanding morning this morning with Owen Carolan telling us where Irish law is at the moment, and really explaining the complicated path our law has taken to get us where we are now. What we're going to deal with this afternoon is how the law is being applied in practice at the moment, which is of extreme importance in my view. And we'll first hear from Professor John Higgins from Cork University Maternity Hospital on the obstetrics side of things. And then we'll hear from Professor Anthony McCarthy, who's a consultant psychiatrist in the National Maternity Hospital in Holles Street. And he's the clinical director in the Department of Psychiatry at St. Vincent's University Hospital. And both Professor Higgins and Professor McCarthy will talk about the circumstances in which a woman would present to a hospital requiring an abortion, and the process by which she could obtain one under the protection, under what I've been calling the Act of 1913, the Act of 2013. Sorry, slip of the tongue. So I'll call on Professor Higgins first.
Thank you very much indeed, and thank you for the privilege, I suppose, of being asked to speak to the Citizens' Assembly. You have a copy of my paper, I think, and the slides are really just a shortened version of that, and I'm going to in essence, try and use 3 cases to illustrate the task that I've been given, which was to explain what currently happens in Irish hospitals. And to a large extent, I think it's important to say it's what has always happened in Irish hospitals. The 3 cases I present, the first 2, in fact, would illustrate cases that we would see, not commonly, none of these cases are common, but they would have occurred essentially always, as long as we've been looking after pregnant women, and we have treated them in the same way. The 2013 Act probably put a legal framework on it, but in my experience it hasn't actually changed the practice. So that's important. So, as you know, and you're probably much more expert than me now in the actual legalities of this situation and the law itself, but one of the things that the Act ensured was that the data around these types of complications and pregnancies were in fact available and submitted to the Minister, and that information is there, and you can see the summary from the first 2 years. So if you see the total number there, they're not big numbers in terms of Ireland's maternity services. Our birth rates are over 60,000 a year. So these are complicated, difficult cases, and I would say, if I can, that looking after women with complications such as these, one of the most challenging things we do professionally, but also from a personal point of view. And we have a lot of good research in Cork on the effects on the caregivers, the clinicians looking after complications like these, how difficult they are. So they're not easy cases. So I've said this, I think. The first 2 cases fall, if you go back to that Act, there's 3 sections that I think are pertinent, 7, 8 and 9, and 7 and 8 refer to conditions where the mother's life is in danger from a physical problem, we call it that, and 9 from the risk of suicide. And I suppose I would say that from our point of view, the mother's life being in danger, we would try not to actually differentiate between different types of risks, as long as the risk is real and bringing the pregnancy to an end is the treatment, we wouldn't differentiate between the conditions themselves. So let's look at the first clinical history. And this is these histories, by the way, they're not real people. They're all called Mary Murphy. It's not because I'm from Cork, but they're simply to make the point that they could be, though. And the stories that I'm telling here absolutely reflect real life scenarios, but they're not of themselves real people. So it's very important to say that. So this first clinical history is a 33-year-old mother of two. She's booked to a local hospital. First two pregnancies completely uncomplicated. So really expectation is that everything will be great. That woman has a fantastic, if you look at what's her likely outcome is everything is going to be great. And unfortunately this time though, at 18 weeks gestation, so just what do we mean by that? Normal pregnancy is 40 weeks. And most people know that, but not everybody. So 18 weeks, that's very early. And she presents to the emergency room and she has noted that she is leaking clear fluid from her vagina. Now, that is something that doesn't happen often, but we would be it wouldn't be something that the staff would be surprised about, because they would immediately suspect that the membranes that surround the baby normally, that protect the fetus in the womb, that they have ruptured. And that's what, as the case, you probably read the case, that's exactly what transpires. So they examine her and they come to the conclusion, yes, the fluid around the fetus has in fact leaked away. So she's admitted to hospital, and that would be standard, and she's monitored very closely. She'd be monitored every 4 hours, particularly temperature and pulse. She's a special blood test done, they're taken regularly. And all the focus actually would be to ensure she's not developing an infection, because those membranes, that sac around the fetus, normally protect the fetus and allow it to develop normally, because they need fluid for normal limb development and so on, lung development, but actually they also protect from infection. As I've outlined in the case, 2 weeks later, the woman's still in hospital. So she's kept in hospital, she's been there, been monitored all that time. She goes to bed at night, she feels fine that night, she wakes up and she feels terrible. And her pulse is racing, she has a high temperature, and her blood pressure is low, she is in shock. So this poor woman has developed an infection in the womb called chorioamnitis, and is now, essentially her life is now in danger. She'll be transferred immediately down to high dependency unit, usually maternity hospital, that's the labour ward. And the decision here, in fact at that point, isn't one that we would agonise over. We would certainly have to, I suppose, explain to the woman exactly what's going to happen, but we would have been discussing it with her over the weeks, over the 2 weeks when she was in. And the decision here is reasonably straightforward. I'm just trying to explain it. Would we be unsure of the diagnosis? We wouldn't. And we wouldn't be unsure of the intervention required. And the intervention required would be that we would induce labour. Now, I noticed that Judge Lavoie mentioned the word abortion. That's not a word we would use very much. I'm just saying from the point of view of explanation. We wouldn't use that word very much in the hospital, nor would we almost never use the word termination to this patient. But technically, that is what we are doing. We are terminating pregnancy. But the language and the discussion, while we are very clear what is going to happen, and she would know exactly what's being done, the terminology is important for us. And we wouldn't use the word termination, we wouldn't use the word abortion. So I've outlined a few questions and answers just to kind of illustrate the case more. What were the main causes of concern when Mary presented the emergency room? Well, I've alluded to them. There's a long-term problem. As soon as the waters go that early, 18 weeks, there's a lot of things can happen now to that fetus in terms of development. But the more immediate or a medium-term concern within the pregnancy is that the mother is now at risk of infection, and if she does become infected, we will need to intervene as we have in this case. Of course, what we're hoping is that that doesn't happen for, some of the cases, of course, that wouldn't happen until 34 weeks or 32 weeks, and the outcome is very good for mother and baby. But in this case, because it's happened so early at 20 weeks when she eventually gets unwell, we know what the outcome will be. So what is the treatment when this infection takes hold? Well, she certainly would be given antibiotics intravenously, but the treatment once she has an established infection in the womb is delivery. And that really is the treatment regardless of the number of weeks the mother is. And we know, because question 3 says 20 weeks and 1 day, what would be any hope that the baby is born alive, that it would survive? The answer is no. So we know that in advance. But we also know that both for the mother and the fetus, if we don't intervene, they most likely both will die. So question 4, what is the main cause of concern? Well, I've answered that already. I seem to be answering the questions in advance. Question 5, what are the main procedures and processes? Well, you probably all know the answer to that too. I won't ask you to answer it though, because you've been reading the Act. But in practical terms, for us, that would be two consultant obstetricians. And I know in the Act you need one obstetrician, but actually in someone with this disorder, you would have a second opinion from a consultant obstetrician. Both would confirm that this intervention was required, and then there's a notification requirement and so on in the Act. That scenario, as I said, has been occurring, forever, and we've been dealing with it in the same way. But the Act does provide a framework and a notification, which I think is helpful anyway. The second case, a little bit different, but again, and a rare thing, actually more rare than the first case, but almost a sentinel story for human pregnancy. All obstetricians would recognize the story. This disorder that I describe is the sine qua non of pregnancy and a complication of pregnancy. First time mother, 42 years of age. So 42, that's quite common. We think about that now. It's not what, we have a high rate of women over 40. So she's booked on her first pregnancy. So she'd be the focus of increased attention in the hospital because of that. But she's fit and well, but her family history is significant. Her mother's first pregnancy, that's not her, but her mother, was complicated by very early onset, she calls it toxemia. So she was, I think, the second pregnancy, as it were, that her mother had. Now, that would again make us think, that's unusual, we know it happens. It makes the mother, the patient we're looking after here, more at risk of toxemia, and we'll give it its real name in a second. So at 19 weeks and 5 days, Mary attends her GP. She feels a little bit unwell, a bit agitated, a bit jittery, a strange feeling. And the GP, he checks her blood pressure, because he immediately would bother him if that was the concern. And she's got very high blood pressure, and he checks her urine, which is the follow-on from that, and it's full of protein. And sends her straight into the emergency room. Now, 19 weeks and 5 days, very unusual to present like that, but it does happen. So this disorder usually occurs later on, but every so often you see a case like this very early on. And at the maternity hospital, she's had bloods taken and a range of investigations, and they show evidence that there's damage to her kidneys, to her liver, to her blood clotting system. She continues to feel unwell. She has a headache. She's admitted to a high dependency unit, again on the labour ward, and she's given her a range of medications, particularly to try and lower her blood pressure and to prevent something that may happen in her, that is seizures. So this disorder we now call preeclampsia. It was classically called toxemia. The population, or patients often refer to it as that. And if a mother fits subsequent to that has a seizure, we call it eclampsia. Both those disorders, both a fit, a seizure, or if the blood pressure is very high and she has a stroke, which is another distinct possibility. Both of those can be associated, obviously, with maternal death. We also know that once we've made that diagnosis, and early onset cases we'd exclude other things, that the only treatment that really is effective is delivery. And it's not the baby that needs to be delivered, it's the placenta. The problem is the placenta. I know that's paradoxical, but that this disorder only happens when you have a placenta or an afterbirth. So, question 1, is this type of preeclampsia unusual? Yes, very unusual, but recognised. We know it exists. In a big hospital, we'll see this every few years. What would be the main cause of concern for Mary's well-being? Well, I mentioned that. 2 big things. 1, she can have a stroke. 2, she can have seizures, and both of those have a high mortality associated with them. Are there not medications one could use to treat this disorder? Well, we can help with the blood pressure, we can attempt to lower it, we can give medications to try and prevent seizures. But in this progressive disorder, it's inevitable that our treatments will fail. So it's only a question of how long we can put a brake on things. We can't reverse this disorder without intervention. And again, question 4, what are the main procedures and processes? They're very similar to the previous case. The difference, I think, in this one would be that we certainly would have got other opinions, I mentioned that, from other medical specialists, just to be sure it's not some other atypical disorder. There's a number of medical things that could mimic preeclampsia. So they would be involved, but usually the final decision would come down again to 2 obstetricians, 2 senior obstetricians, confirming that the diagnosis is likely to be severe early onset preeclampsia. And then there's a discussion, which of course Mary would be involved in anyway from the start, and an intervention. And what I mentioned here was that 3 or 4 days afterwards, everything is returning to normal. So by and large, that you can absolutely cure this disorder. It doesn't continue to progress, it goes away. The last clinical history is, I suppose, very pertinent to the Act in the sense that it wouldn't have been as clear a component of our long-standing practice. And that relates to the area of suicide. And this is a case or history of a 28-year-old woman. She's pregnant for the first time, long history of depression since her teens, and has been admitted several times. And she attends her GP about 8 weeks. She thinks she's pregnant, and that's confirmed. But her GP, again, very worried when he sees her. I think she's very low, concerned enough to ring directly to her psychiatrist who's been looking after her for the last 12 years. And she's seen a couple of days later, and a lot of the focus of Mary's depression, suicidal ideation, which she articulates, is around the pregnancy. So it's not just that she's depressed and she feels suicidal, she has a focus in terms of the pregnancy, and she's referred into the maternity hospital. She has a scan to confirm, it's very important to confirm that the pregnancy is ongoing, and she's then seen by a psychiatrist attached to the maternity hospital. He has a long consultation with her, and again concludes she's very depressed with suicidal ideation, and he believes that this places her life at significant risk, and contacts her consultant psychiatrist to discuss his concerns, and then the consultant obstetrician on call is asked to see her. In this case, I just mentioned that the consultant on call actually refers her to a second obstetrician, who then meets Mary, and a decision is made. In this case, and again, the terminology at 8 weeks is slightly different. It's interesting, but even in terms of explaining it to the patient what we're talking about doing at 8 weeks, it's hard to talk about delivery at that stage. So termination is performed, and after the procedure, the mother is admitted to her local psychiatric hospital. I thought I wouldn't do my questions and answers because I know we're going to hear a more detailed discussion on that section of the Act, and I might just leave it there. And of course, I'm going to take questions and be available for the workshop. So thank you very much indeed.
Thank you. We now hear from Professor McCarthy.
Hello, good afternoon. I'm delighted to be here. I think it's a very interesting idea, this idea of the people hearing, listening, thinking, asking questions, and coming up with decisions, representing the people in general, and particularly on such a difficult area as the Constitution, and particularly on the issue we're discussing today. The Chief Justice started by talking about the complicated path of how we got here. I'm going to be dealing with possibly one of the most complicated parts of the consequences of how we got here. The Protection of Life during Pregnancy Act 2013 was the first time that termination of pregnancy was allowed in this country on the basis of suicidal intent. In other words, a belief, an understanding that a woman just wasn't thinking of committing suicide, but that there was a real and substantial risk that the woman would kill herself in pregnancy unless she had a termination. This piece of the legislation refers in reality to a very tiny group of women. And I'm going to start by saying why it applies to such a tiny group of women, before actually dealing with the actual procedures involved. So the first condition is that the woman has a pregnancy that she does not want. As you may or may not know, approximately 50% of pregnancies are planned, 50% are unplanned. And of the unplanned, that does not mean they're unwanted. Many are wanted. It may be a shock that they're pregnant or it was unplanned, but either immediately or with time, she or both will be delighted, and in the end will have a baby who will be one of the most meaningful, joyful, important people in their life, and it will all end in that way, which is wonderful. The reality is, though, that pregnancy is not like that for everyone, and for a lot of women with unplanned pregnancy, it is an unwanted event. And that unwanted event may or may not cause them depression, distress, trauma, shock, etc. But the vast majority of women in Ireland who have unwanted crisis pregnancies are not suicidal and are not saying they're suicidal. They may just decide to have a termination of pregnancy. The reasons that they are pregnant can be varied, of course, but it's an unwanted pregnancy. And as a result of that, they will travel to the UK or elsewhere to have the termination of pregnancy. Thousands do this every year. Or they will order tablets over the internet or access tablets to try and induce a medical abortion themselves. That's reality. That's not psychiatry. That's not suicide or anything of the sort. A lot of women are depressed in pregnancy. There's an illusion sometimes, there's a thing called postnatal depression that everybody knows about. The reality is depression is very prevalent in pregnancy as well. It's estimated that somewhere between 11 and 13% of women will be depressed in pregnancy. We could be here all day discussing what does depression mean. Every one of us in our lives, if we've any experience of life of being depressed, we're all depressed sometimes, either depressed, it's a normal part of human reaction. When disappointing things happen in relationships, in our work, in our life situations, after bereavements, traumas, sometimes just depressed about ourselves, disappointed with ourselves, part of the normal life journey. But sometimes that depression is much more severe, much more serious, and sometimes becomes unmanageable, and sometimes, particularly if that occurs in pregnancy, can be a profoundly challenging experience for any woman. However, the vast majority of women in pregnancy who are depressed are not suicidal. They may have suicidal, the word suicidal ideation flies around all over the place. A lot of people have suicidal ideation. A lot of people wake up in the morning thinking, I don't want to wake up today, I'd rather be dead. That's a passing thought. People can have suicidal ideation of a more severe nature in pregnancy as well, where they're haunted, but they're profoundly depressed by suicidal ideas coming into their mind, images constantly of dying, imagining themselves jumping over a cliff or driving into a wall or whatever. The vast majority of women who are depressed in pregnancy do not want to die. The vast majority of women in pregnancy who have suicidal ideation do not want to die. The vast majority of them want help with their depression. And the vast majority of them are not thinking that they want a termination of pregnancy. Pregnancy may or may not be a small part of it. It may be the trigger, but it's not necessarily their thinking, oh, but if I have a termination, I'm going to be okay. So this law states that the woman firstly has to have an unwanted pregnancy, secondly has to be depressed, third, wants a termination of pregnancy, and fourth, thinks that if she has that termination of pregnancy, that will be the cure for her. That will at least alleviate her depression. And it's only in those circumstances that the legislation begins to apply. So if she feels that, then she will present herself to a psychiatrist. Now, how she gets there is a question. She may present to a crisis pregnancy unit, to a general practitioner, to an emergency department, to an obstetric hospital, but she'll present. And she has to be assessed first by a consultant psychiatrist, not by any junior psychiatrist. And actually accessing a consultant psychiatrist is not necessarily the easiest thing in any emergency. And that psychiatrist then has to assess her to be sure, not to be sure, but to assess whether all these criteria have been fulfilled and whether this woman really does want a termination of pregnancy and whether she is so depressed in herself she's lost the capacity to make the decision or not, or does have the capacity to make that decision. Is it likely to be an ongoing thought? Is it a transitory thought? Is she just having suicidal thoughts? She could even be rarely psychotic, have a voice in her head telling her to kill herself, in which she needs psychiatric treatment, not a termination. In other words, make a comprehensive psychiatric assessment, making sure that her decisions are well thought through, because we have to be aware in making the decisions that the termination may, yes, protect her life. It may also be harming for her. We know that some women are damaged by terminations of pregnancy. And there's a lot of research on the psychological consequences of termination, which obviously in this space I don't have time to discuss. If that psychiatrist is of the view that yes, she fulfills these criteria, yes, she's profoundly depressed, yes, she wants a termination of pregnancy, yes, that is the only option for her, well then they will have to ask a second consultant psychiatrist to see her. And this psychiatrist has to have some experience in this area. That will not be easy, because there aren't too many psychiatrists who have that experience, and there aren't too many psychiatrists who want to be involved here. Because this is very controversial. It's highly charged, it's highly politicized. So it's very difficult in getting a second psychiatrist. And if this woman is under the age of 18, if she's a child, technically under the Mental Health Act, somebody under the age of 18, it has to be a child and adolescent psychiatrist who will see her. And they also have to agree that all of these criteria have been fulfilled. And if that's the assessment, they also have to then, of course, involve the obstetrician, who also has to agree that all of these criteria have been fulfilled. In the event of all three agreeing, well then she will go on to have a termination of pregnancy. The reality is, as I said, looking at all of those criteria that I've listed, this refers to a tiny number of women. And in my clinical experience and clinical experience of any psychiatrist working in a maternity hospital, almost my first question in a situation like that will be almost, why has she not gone abroad? Why would she put herself through this? Because if you are a woman who's profoundly depressed and suicidal and distressed, to talk to one person, one consultant, one stranger about the circumstances of the pregnancy, their mental health, their personal story, what may be behind all of this, is itself a difficult experience. And of course that consultant might not even have been the first person. They might have presented to their general practitioner, to crisis pregnancy agency, to a junior doctor first. So to begin to tell that story to one psychiatrist, to try and tell it to a second psychiatrist, another stranger, and have to wait. It could be waiting a few days, it could be waiting a few weeks to get a second consultant to see them. And then know that she might be turned down. And that if it is turned down, then she would have to go to an appeals panel. And it's great there's an appeals panel there. That's an appeals panel where she'd have to talk to two more psychiatrists. and a second obstetrician, possibly 2 obstetricians the first time, 2 obstetricians the second time. Why would she put herself through that? And the circumstances of herself putting herself through that are likely to be relatively uncommon, relatively rare. Of course, it may apply to those who for some reason can't leave the country, maybe because of their visa issues, they're refugees. It may be someone who's in care, a child in care. It may be somebody with learning disability. These are all rare possibilities, but it's a very small number of women who, looking at this, knowing this, will actually want to go through it. Remember when this legislation was being drafted, there were sort of beliefs somehow that women all over the place would be presenting psychiatrists, saying they're all suicidal and fooling psychiatrists, and there were people talking about that young women would be looking at books on the internet and how to fool psychiatrists and presenting in this way. That simply has not happened. It was never likely to happen. Because, and as you know from the figures, we've had 3 terminations last year under this Act, 3 the year before. There have only been 2 appeals in the over 2 years as well. One of those appeals went on to be one of those 6. One appeal was turned down. So 7 women have presented to be assessed just over a 2-year period. Out of the in 3 years, 180,000 women plus who've been pregnant in Ireland. And if we take 13% of those being depressed, that's a lot of women who are depressed in pregnancy who've never gone near this situation. So that's who it's referring to. And as I said, the appeals group will again be 2 consultant psychiatrists who will again have to see the woman, take her history, assess and evaluate, and another obstetrician. So I suppose the last point to make is just for you to be aware, suicide does occur in pregnancy. I am on the confidential inquiry into maternal deaths in Ireland and Britain, have been for the last 8 years. So I see, unfortunately, read the case notes, read the histories from general practitioners, from the obstetricians, from the psychiatrists, of women who have killed themselves in pregnancy. It's rare. We'd expect one in Ireland approximately every 4 years on the statistics. But it may be more common than that because suicide is always underestimated. And we know that a case where somebody might drive into a tree or drive into a wall that appears to be a road traffic accident is sometimes suicide. But it still is a very, very small number. But it does happen, it is real. And when it happens, it's always a tragedy. And of course, we will see not just that the mother has died, but also her unborn child or children. And sometimes leaving behind other children as well. So it's real, it's a tragedy, it's substantial. But that's how the Act works in that small percentage of women who eventually will present to the maternity hospital or their GP or psychiatry in this way. Thank you.
Well, now we're moving on to part 2 of this session, and before we do go there, I have to give my sincere thanks to Professor Higgins and Professor McCarthy. The 2 presentations we're about to hear now also deal with the operation of the law in Ireland in practice. First of all, Janice Donlan from the Crisis Pregnancy Programme will outline the role of the Crisis Pregnancy Programme and in particular the role it plays in supporting women in crisis pregnancy, and she will also give us a wider overview of crisis pregnancy in this jurisdiction. And then we will have Dr. Brendan O'Shea from the Irish College of General Practitioners, which has a regulatory function, as you know, in relation to general practitioners. And he's also a practicing general practitioner. And he will give us the perspective of the GPs in Ireland and how they interact with the law as it stands. So we're still with the law as it is at the moment. So we'll hear Janice first.
Thank you. Good afternoon, ladies and gentlemen, and thank you to Justice Lavoy for the opportunity to speak with you today. I know you would have received a briefing document from ourselves, and I know there's a lot of information within it, and there's a lot of information within the presentation also. So I thought I'd just give a brief overview of what we're going to look at today. We're going to look at the remit of our programme, which is the HSE Sexual Health and Crisis Pregnancy Programme. We're going to look to see where crisis pregnancy sits in legislation, who experiences a crisis pregnancy, the decisions made following a crisis pregnancy, some key research, statistics and trends, and also look at the role of funded services. So our programme sits within the HSE and it has responsibility for addressing crisis pregnancy. And we really do that through two strategies. We have a strategy on sexual health strategy, and we also have a crisis pregnancy strategy. And the work of the programme is broken into 4 functions, and 2 of those functions will be addressed today. There is a funding of services, so that's funding of crisis pregnancy services, and there's a research and policy function as well. And really, the research function within the programme underpins the work of the programme. And much of the research that we present today is research that has been commissioned by the programme. So we can see here that crisis pregnancy is defined in Irish legislation. It's defined in the legislation that set up the Crisis Pregnancy Agency. And it's defined as a pregnancy which is neither planned nor desired by the woman concerned, and for which represents a personal crisis for her. We also recognise that this definition includes the experiences of women for whom a planned or desired pregnancy develops into a crisis over time due to a change in circumstances. If we look at research, we can see that crisis pregnancy is common. It's a common phenomenon. Approximately 1/3 of women who have been pregnant in Ireland have experienced a crisis pregnancy. We see that women and their partners who have a crisis pregnancy come from all socioeconomic backgrounds. The majority of the women are married or in a stable relationship when the crisis occurs, and they come from every age range. The average age of when a crisis pregnancy occurs is 24 years for a woman and 25 years for a man. And this shows that the often held perception that crisis pregnancies primarily happen to teenagers is unfounded. We're now going to address just some of the issues as to why a pregnancy is a crisis, and really there's a variety of reasons, often particular to the age of the woman and the point in her life that it occurs. The most common reason is because the pregnancy isn't planned. Women and their partners often consider themselves too young, and with the average age of childbirth increasing year on year, we can see that women in their 20s who may not have considered having a child at that point in their life, it's not an option for them. Other reasons were reported were financial, relationship concerns, or health concerns also. We're now going to look at some of the decisions made following a crisis pregnancy. And again, we can see that research shows us that 73% of respondents in a 2012 study chose to parent following their most recent crisis pregnancy. Abortion was the second most reported decision, with 24% of women reporting they had an abortion following their most recent crisis pregnancy. And adoption, whilst once a common decision following a crisis pregnancy, has really reduced significantly from the 1970s, where there was nearly 1,500 adoptions, to 7 domestic infant adoptions in 2015. We're now going to just look at the option of abortion in a little bit more detail and see some of the data that we have on it. We can see that the UK is the most common destination for women to travel for an abortion, so we'll look at that data in some detail. The Department of Health in the UK gathers data from abortion service providers on women who provide Irish addresses in UK abortion clinics. In 2015, 3,451 women gave Irish addresses at UK abortion clinics. This is a decline since 2001, when 6,673 women gave Irish addresses, and the decline has been gradual over those years. We can see with this graph that the rate of abortion has decreased from 7.5 women per thousand in 2001 to 3.6 women per thousand in 2015. The 2015 data has been broken down by the Department of Health in the UK to provide some characteristics of the women that travelled in that year. We can see that women were from all 26 counties. The majority were in their 20s or early 30s. The majority had an abortion before 9 weeks gestation. Majority were married or in a relationship. The majority were white Irish. Just under half reported having a previous child, and approximately 1/5 had a previous abortion. We also know from research that women of higher earning power are more likely to travel for an abortion than those of lower earning power. If we now just look at the issue of the abortion pill and the use in Ireland. Abortion pills are designed to induce an abortion in pregnancies that are less than 9 weeks gestation, and they're used in medically supervised clinics in countries where abortion is legal. The supply of abortion pills or any other prescription medication over the internet is illegal. And whilst it is illegal to both supply and take the abortion pill in Ireland, some women are still accessing and taking abortion pills bought on the internet. There has been limited information and research available on the use of abortion pills by women in Ireland due to the illegality of the practice. However, a recent research study published in October 2016 in the British Journal of Obstetrics and Gynecology examines the experiences of Irish women seeking and taking abortion pills accessed from the online provider Women on Web. The study shows that over a 6-year period, between January 2010 and December 2015, a total of 5,650 women from the island of Ireland consulted with Women on Web. In 2010, there were 548 online consultations, and this increased by more than 2.5 times in 2015 to 1,438 consultations. The study further breaks down the period during 2010 to 2012 to show that 1,642 women were sent the abortion pills within the island of Ireland. Whilst it's difficult to make an assessment on the issue of abortion pills in Ireland from one study, it does highlight the recent increase in women seeking information or seeking access to abortion pills online. So the next part of the presentation, we're going to look at some of the crisis pregnancy services that are funded by the HSE and available to women and their partners who experience a crisis pregnancy in Ireland. Some of the services are provided through the HSE, as I said, funded services. Counselling on all 3 options are provided under the legal framework of the Abortion Information Act 1995. And the Act sets out how information on abortion about legal abortion services outside of Ireland may be given to women and their partners in Ireland. The HSE funds 16 services in over 40 locations nationwide, and they're set out there on the map. Crisis pregnancy counselling is provided free of charge through state funding of the crisis pregnancy counselling service, and research finds that some women who experience a crisis pregnancy may resolve the crisis themselves, but others may rely on the support of their family or friends or a health professional, including a GP or a crisis pregnancy counsellor. All funded crisis pregnancy counselling services provide non-directive, non-judgmental, client-centred counselling to allow the woman space to reflect and make her own decision on the options available to her. The woman is given space to explore all of her options through the counselling session. And the Abortion Information Act clearly sets out where a woman seeks information on legal abortion services, she must be counselled, advised and fully informed on all the options that are available to her, including parenting and adoption, before information on the names and addresses of abortion clinics can be given. We see also that the Abortion Information Act sets out that counselling services in Ireland must not be seen to promote, advocate or benefit financially from an abortion service provider. The counsellor is not permitted to make a referral or an appointment for the woman. She must do this herself. The law also does not oblige any individual to provide information on abortion services and allows for conscientious objection. Within the 16 funded crisis pregnancy services, 2 services do not provide information on abortion clinics due to the ethos of their service. All funded services must display their ethos on their website and other advertising material and must outline to a potential client what information they can and cannot provide. An appropriate referral to another service must be made where the agency does not provide requested abortion information due to their ethos. If we look at the Abortion Information Act, it's recognised that it is over 20 years old, and in those 20 years there have been many developments in technology and access to the internet. Many men and women are now bypassing crisis pregnancy counselling services and accessing information directly from the internet. And the reduction in crisis pregnancy counselling and numbers attending crisis pregnancy counselling may reflect this situation. we can see that the numbers accessing crisis pregnancy counselling services have reduced since 2004, where there was a high of 9,158 down to 2,787 in 2015. While the numbers attending services are decreasing, service providers report that those attending services are experiencing more complex and more multiple issues. We in the HSE have commissioned a review of all funded crisis pregnancy counselling services in order to put in place a sustainable plan that reflects the changing demand for crisis pregnancy counselling. We must note as well that whilst the 16 crisis pregnancy services funded by the HSE provide non-directive, non-judgmental counselling under the requirements set out by the law, not all services claiming to provide support to women are genuine. These counselling services are set up to influence the choice a woman makes and to pressure a woman into doing something she doesn't want to. They often target women seeking information on abortion, use inappropriate images, and make unfounded claims during counselling sessions. We must remind women who have been affected to report their concerns to the Gardaí and to only attend a service which is funded by the HSE through the Positive Options website to ensure she receives genuine support. Finally, I just want to outline some of the services and supports available to women following a crisis pregnancy and in particular following an abortion. Post-abortion counselling is provided by the same service providers that provide crisis pregnancy counselling. And post-abortion counselling provides a space for a woman to explore her feelings towards the decision made. The uptake is low in Ireland, and this is reflected in other countries where abortion is legal. All clients attending abortion services in the UK are provided with information on the availability of post-abortion medical checkups. These are available free to women through family planning clinics and other GPs, and they provide an opportunity to discuss any medical concerns or long-term contraception needs with a medical doctor. And all information is available on abortionaftercare.ie. We also see that the uptake of these services remains relatively low, but the service is available there free of charge. So I'd like to thank you for your attention, and I welcome any questions you have after your discussion.
And now we will hear Dr. Brendan O'Shea on the GP's perspective.
Good afternoon, Justice Lafoy, ladies and gentlemen of the Assembly. My name is Dr. Brendan O'Shea. I'm from the Irish College of General Practitioners. Thank you very much indeed for requesting the ICGP to have an input in the business of the Assembly today. In delivering our submission and our paper, we have reflected on the activity of the College in this very important area of care during the last many decades. And we've also reflected among ourselves, and we're bringing our observations to you, and particularly taking the brief from the Assembly. We're looking to deliver perspectives from the medical profession on how the current regime operates in practice, and particularly the position on the ground for women who come in and consult in general practice and the experience of general practitioners. With respect to the paper we're presenting, we'd just like to do a very brief background. We'd like to reflect on crisis pregnancy and how we see it in practice on a daily basis, what we've tried to do in terms of prevention of crisis pregnancy, on the management of crisis pregnancy in our communities and our surgeries, and particularly on issues relating to the 8th Amendment. We have some summaries and conclusions for you, and a brief appendix of current observations in terms of how we see things at the moment. General practitioners are particularly familiar with reproductive healthcare challenges facing Irish women. Irish GPs provide antenatal care to Irish women during pregnancy. Before 20 weeks gestation, GPs provide most antenatal care and support to pregnant women in Ireland. After 20 weeks, GPs provide shared care with hospital colleagues in obstetrics and midwifery. So we're very much engaged in this part of care. When a pregnancy is unwanted, GPs frequently support and care for women through this difficult experience. Evidence-based management of crisis pregnancy provided by GPs is set out in relevant ICGP publications, including guidelines on crisis pregnancy from 2004 and more recent updated guidelines from 2014. Further, Irish GPs provide high-quality contraception to Irish women. Thus, we feel that we are reasonably well placed to understand the concerns, the fears, the experiences of Irish women regarding reproductive health care generally, and especially in relation to the area of early pregnancy, unplanned pregnancy and crisis pregnancy. The implications of the 8th Amendment and the associated legislative acts are closely considered throughout this paper. Crisis pregnancy. We've already had a definition, and it's a good definition. It's a pregnancy which is neither planned nor desired by the woman concerned and which represents a personal crisis for her. As we see it in our practices in your communities, crisis pregnancy affects women at any age, of any social group or in any geographical community. Effective management requires attention to a broad range of clinical, social, emotional, educational and legislative issues. The response of the GP or other healthcare professional at the initial consultation is known to have a very important and sometimes profound impact. The importance of the woman and her partner having a personal doctor available through this time, or indeed many other difficult times, is difficult to quantify, but it's greatly valued. It's very important to us as GPs that we maintain that strand of personal care at this really difficult time. Detail is already presented to the Assembly in relation to the incidence and the outcomes in pregnancy, so we're not going to go over that again here for you, but it is sufficient in the context to observe that irrespective of our legislation and the 8th Amendment, termination of pregnancy remains a mainstream aspect of medical care for many women resident in Ireland, for their partners and indeed for general practitioners. Prevention of crisis pregnancy. GPs are well placed to provide effective, accessible contraceptive care to Irish women. GPs, we hope, are still trusted professionals, knowing patients over time with strong doctor-patient relationships. GPs try to promote and be proactive in making available effective and accessible contraception for all women who are sexually active. The greater majority of GPs provide contraception, emergency contraception, crisis pregnancy counselling and post-abortion care, doing so as part of a highly accessible national network of points of readily accessible care. There are GPs and practice nurses in every neighbourhood you care to visit. Despite the efforts of government, educational initiatives and healthcare practitioners, and despite widespread access to emergency contraception, we concur that crisis pregnancy cannot always be prevented, and 35% of all Irish women, as you've heard, who have been pregnant describe having at least one crisis pregnancy. This is really common. It's usual for most GPs as the first point of contact for individuals to encounter women and sometimes their partners in an unplanned, unwanted pregnancy. It is a large-scale issue for us in practice. Internationally, and this is one of our key points for you, abortion rates are lowest in health systems where contraceptive services are most readily available. I believe and we hope in the ICGP that we've come a good way in Ireland in relation to this, but there is more to go. There are definite barriers to contraceptive services in Ireland, chiefly relating to cost, and in instances involving adolescent women, their own concerns regarding confidentiality as well. The 8th Amendment does not typically impact upon contraception and emergency contraception management for Irish women. It has made little or no difference to most GPs and most individuals in their consulting around unplanned crisis pregnancy. Management of crisis pregnancy. To help outline the typical crisis pregnancy scenario, we outline a typical example. And with no disrespect to Mary Murphy from Cork, we have Sandra, who is 38 years of age. She attends her GP, she has 3 children, but recently separated from her husband 3 weeks previously as he had become increasingly abusive towards her and her children. Her GP has become more concerned about Sandra's isolation and lack of supports. Sandra says she missed her period 2 weeks ago. She thinks she may be pregnant, but she hasn't checked yet. She is concerned and anxious. She's arguably on the threshold of a crisis in the consultation. Why didn't she check the pregnancy test before she came? I think if she had 3 children hanging out of her and an unsupportive husband, these things happen. But people come to us in our practice in large numbers all of the time from different circumstances. Before her doctor performs a pregnancy test, she explores Sandra's feelings. She asks how would she feel if she was pregnant, would she be happy if she found she was pregnant, at which Sandra bursts into tears. The GP listens to her many concerns, readily shared, and explains clearly that no matter what happens, the practice will be there to support Sandra today, tomorrow and next week and well beyond that. The GP proceeds to check a urine sample and it confirms that Sandra is in fact pregnant. She is despondent and devastated. She says she doesn't want to be pregnant. Every crisis pregnancy is different. The reasons why a pregnancy is unwanted is both personal and unique to each individual woman and her family, but the approach to managing crisis pregnancy as a doctor, as a primary care physician, as a general practitioner must be the same. We must confirm the pregnancy. As the vignette outlines, GPs do not assume that all pregnancies are always wanted. GPs are well placed to sensitively inquire about the woman's feelings and to confirm a pregnancy. And we hope that we do that in as many cases as we can, knowing that sometimes because of the feelings and the concerns, there's a miscommunication or there's difficulty in the communication. It's very difficult to be fully sensitive at all times, but we do our best and we do hope and we do feel and believe that most of the time the experience is positive and supportive despite the difficult circumstances. We proceed to non-directive counselling and discussion of options. Next steps in management are to support the woman reach the best decision for her. Main consultation objectives for the GP involve maintaining or establishing trust, helping the woman formulate a clear definition of what the problems are, and establishing the goals of management so that the crisis can be resolved for her. This involves non-directive, non-judgmental, compassionate, empathetic listening. One of my colleagues in our run-up to preparing for this observed that often the best thing we can do is to remain silent, that the opinion of the GP should be silent, that the focus should be on listening and on understanding. A doctor has an ethical obligation not to allow her own personal moral standards influence the treatment of patients. Where the doctor has a conscientious objection to a course of action, they must explain this to the patient and make the names of other doctors available to them. This has been stated through ICGP policy and training from the early 2000s and most recently in our updated guideline from 2014. Effective communication in crisis situations demands time, considerable patience and careful thought. The GP must enable a woman to reach an informed decision to alleviate emotional disturbance, whatever decision is made, and lessen the risk of further unwanted pregnancy. Pre-existing long-term relationships between GPs and the people who attend them is critical in enabling this. In practical terms, this may mean 2 or 3 consultations scheduled rapidly over 5 or 10 days. In the familiarity of general practice, we hope that women do find space, are listened to, and can share, explore and address their concerns with their own doctor. Supporting this is a core value of the ICGP, so that these consultations, and indeed any other consultations involving the woman and the process of decision making, are all undertaken in a non-directional and fully supportive process. Occasionally, specialist counselling is required. For example, if a woman is younger, has poorer support structures, or has a significant mental or psychiatric illness, they may benefit from specialist counselling. In this case, Irish GPs recommend specialist accredited counselling services which offer accurate information. These are funded by the HSE Crisis Pregnancy Programme, and by and large they enjoy the confidence of the ICGP and have been extremely helpful during these last difficult decades around this issue. Continuing the pregnancy. If a woman chooses to continue her pregnancy, her GP will continue to provide compassionate support, antenatal care, postpartum care to her and support for the child. Choosing abortion. In the clinical vignette above, our patient Sandra chooses to travel to the UK for an abortion. For women who choose an abortion, GPs cannot refer or make an appointment on behalf of the woman to a clinic in the UK, but would typically make a copy of the medical records available to be taken over as part of the care process. GPs would also encourage women to return to the practice after the abortion if they have any concerns. GPs would also discuss post-abortion contraception. Irish GPs may need to consider arranging an urgent dating ultrasound, for example, if the dates around the pregnancy are uncertain, which not infrequently happens, particularly if the social background is chaotic or stressed. Any GP who has a conscientious objection must refer the woman to another GP, either within or outside of their own practice. Medically, abortion is regarded as a relatively safe procedure for the woman, and it is carried out in large numbers in other jurisdictions. We note that some women, those for example who are disabled, with a physical disability, without financial means, individuals who are on direct provision, asylum seekers, are particularly disadvantaged and unable to travel to access abortion services. The ICGP understands that an increasing proportion of women will purchase online hormonal abortifacient medication. In these instances, it may or may not become known to their GP in subsequent consultations, but we find over time that everything comes out in the wash. It may come out 1 or 2 years later, or possibly 5 or 7 years later. There is clearly increased use of illegal abortifacients, both from anecdotal evidence from GPs and objective measures such as custom seizures and the studies that we've previously heard from Janice. Issues pertaining to the Eighth Amendment and relevant legislation. We've slotted this in under a heading, Cumbersome Clinical Guidelines, and these have been referred to by my obstetrical colleagues and the difficulties that the current amendment throws up in this context. The Eighth Amendment and the Protection of Life During Pregnancy Act 2013 allows for lawful abortion where there is a real, proven and a substantial risk to the life of the mother. This is the legal concept. You've already been given data in relation to the huge infrequency with which this legislation is invoked, so I won't go over that again. It is in the paper that we're providing for you and will be accessible to you. In rare cases under Section 9 of the Act, process is characterised by substantial delays, typically 4 to 6 weeks at a critical period in accessing termination of pregnancy. Further evaluation by a second psychiatrist, frequently outside the woman's community, really adds to incredible difficulties in this tiny number of cases. The Abortion Information Act indicates that GPs can and do discuss all options pertaining to crisis pregnancy. However, the 1995 Abortion Information Act does not permit GPs to either refer or to actively advocate abortion services. This restriction on practice can be challenging when caring for women with complex medical histories or with high medical risk, but we get on with it. Inaccurate information from counselling agencies. We would concur with the observations of Janice. We would like to point out that inaccurate information which is delivered by unaccredited counselling agencies is sometimes viewed by GPs as harmful and needs to be regulated. It particularly tends to incur delay, is the experience we have with it, at a time when delay adds to medical risk and adds to the stress and the tension perceived by the individual. Winding down, again, we would care to wish you the very best in the work that you're doing, and we greatly appreciate being consulted in relation to this because we regard this as an important part of the care we provide in your communities as general practitioners. Most GPs and many individuals who attend GPs in the course of an unplanned pregnancy do not experience the Eighth Amendment or the process required for the operation of the current legislative framework to be satisfactory, relevant or helpful. Crisis pregnancy continues to be a reality facing many women and their partners in Ireland on a daily basis. It is conspicuously evident in general practice, and a substantial proportion of these women choose to access means of termination of pregnancy. In the last 2 decades, there is a shift from surgical terminations to chemical or medical terminations. And in Ireland, if we look at other European states, we're probably about a decade or a decade and a half behind. But this is what's happening in our communities. From a practical perspective, and respecting cherished and sincere concerns regarding the right to life of the unborn child, the majority of GPs, and indeed Irish citizens, will understand and acknowledge that in many instances of unplanned, and especially crisis pregnancy, a substantial proportion of women in Ireland will continue to choose and undertake termination in neighbouring jurisdictions or by means of medical abortifacients. From a purely whole of society perspective, building on good work already done by many agencies, including our own college, in removing all the remaining obstacles and barriers to contraception for all women, almost certainly holds greater potential in terms of reducing the numbers of crisis pregnancies and ultimately meaningfully reducing the number of terminations in a meaningful way. In preparing for this submission, we did review our procedure, the training that we've put in place for members of the Irish College of General Practitioners and GP trainees, and we did also consult among ourselves as much as time allowed between the request for our submission and preparing it. And we have made it our business to consult among ourselves. It is our collective experience now in general practice that in the majority of such instances of unplanned undesired pregnancy, the woman opts to follow through with the pregnancy. This is felt to most likely occur among women from more deprived backgrounds or migrant backgrounds and living under direct provision, where cost of termination and ability to travel are real barriers for these women. There is a tacit assumption among many GPs that reduced levels of enfranchisement result in increased levels of acceptance of continuing with the pregnancy. Women disadvantaged in these circumstances undertake to maintain the pregnancy as they see it as the only viable option to them. It is evident to many GPs that the decision to continue with the pregnancy is frequently taken on the basis of financial considerations and non-standardised access to service. Poor women accept pregnancy because they can't get together €1,000 to fund a termination abroad. Women from less deprived backgrounds are more likely to undertake a termination because they and their partners can afford it. This reality in practice clearly adds to the sense of suffering for an important proportion of women, their partners, and in some instances their GPs. Inequality is writ large across most aspects of our health service, and this area of care is no exception. In keeping with current legislation, GPs do not provide formal referral letters to abortion clinics. Some GPs provide women concerned with a copy of their medical notes. In such instances where the choice is made for termination, GPs do remain engaged with their patients for the most part and have felt it necessary to continue to reassure any undue concerns regarding substantial or increased levels of mental health or gynecological complication arising among women following terminations. This is in keeping with international research. These women are still unnecessarily afraid about complications and side effects of termination. The prevalence of postpartum depression is a reality for those women who elect to continue with the unplanned pregnancy and requires to be considered. It is a real issue for GPs and their patients in this context, where unplanned pregnancy is a known risk factor for postpartum depression. Preoccupation around suicide, around diagnosis of unplanned pregnancy, is far less of a problem than postpartum depression in the wake of continuing with an undesired unplanned pregnancy. Ladies and gentlemen, thank you very much for your attention and your consideration. Thank you kindly.
Well, I really want to thank all of the speakers in this two-part session this afternoon. There was an awful lot to take on board, wasn't there? We're now going to go into private session, and you'll have an opportunity to take it on board further by discussing the issues that we have heard about around the table. So our next public session will be at 4:30, and at that time our four speakers will answer questions posed by the members. Thank you very much.
des Himmels prächtigen Land laufet Brüder eure Bahn, laufet Brüder eure Bahn, freilich wie ein Held zum Siegen, wie ein Held zum Siegen, laufet Brüder eure Bahn.
Citizens, advisors, friends. It's 4:30, so we're starting. It's exactly 4:30, isn't that right? And we're starting on our final public session for the evening, and this is a question and answers session on what we heard this afternoon, on the topics in the four really interesting presentations we had this afternoon. Now, I'm about to be characterised, I think, as the most boring woman in the world, if not the most boring woman in Ireland, if not in the world, because once again, I have to say to you, you've heard it probably several times already today, I have to remind you that the should be confined to points of information based on the current regime. That's what the speakers came here to talk about. They came here to talk about how the current law operates in practice. And that being the case, I don't think they should be asked, and I don't think they should be expected to answer questions on the perceived advantages or disadvantages of the law or how it is applied. Now, I know there is an element of frustration in relation to that. I'm fully appreciative of that. But we will have another occasion, and it may be that our speakers here may like to make a submission later on a question that's raised. But in any event, we're proceeding on the basis on which we invited the speakers here, and that's in the interest of fairness. And as I say, every effort will be made in succeeding sessions to eliminate your frustration on the questions you want to answer. And I do appreciate your position. So once again, I can tell you that there are a number of roaming mics around the room.
Before we get started, sorry, if I could just say, just to bear in mind that we're having proceedings translated both into Irish and to Irish Sign Language. So just when you're making your remarks, if you could just bear that in mind to speak clearly and slowly, just for the benefit of our translators, that would be really helpful. Thanks.
Very good. So anyway, we're ready to start now, and I'm inviting questions from the floor to our 4 speakers.
Hi, I'm the facilitator for Table 11, and we've got 2 questions.
Yes.
So the first one is, if someone tells their GP that they're going to travel abroad for termination, what provisions are in place if that person has an underlying medical condition, that their records are made available to them immediately, that they can take them with them? Under the Freedom of Information Act, it's 40 days for a response.
In practical terms, this is a situation, and the way that it would be practically addressed by most of my colleagues and myself would be to immediately provide a copy of the medical records on the spot. Most of us operate on the basis that all of our patients, really, that arguably the medical records belong to them in a holistic sense. Technically, I believe they belong to us, but all patients have a right to see their records, unless sight of those records would actually cause harm or damage, which is practically very rarely the case. But in the situation that you've outlined, the practical solution is to, and because general practitioners, unlike the rest of the healthcare system which operates on paper records, general practitioners have electronic medical records. This is a press of a button and there's a copy of your medical records. It's operating within the law to do this. It's not operating within the current law to provide even a note of referral to accompany the medical records.
Our second question is there any agency or body collecting information from the women who do travel abroad for an abortion in terms of why they're doing it, whether it's for health reasons or financial reasons or anything else?
I don't know the absolute answer to your question, but I would understand that from time to time particular pieces of research are undertaken around this, but I don't believe that there's whole system measurement of this.
Yes. I wonder, would Janice have a view on that?
Yeah, I mean, we don't collate data in that manner in terms of the women who travel. The Department of Health in the UK perhaps provides some statistics in terms of the types of women and the characteristics of women who travel, but we don't have definitive information about the particular reasons. I mean, we gave a broad range of reasons that research shows us, and those reasons include financial reasons, relationship breakups, but again, I don't have that information to hand.
Hi, I just have 2 questions from our table that came up from our discussions. The first one is it possible to make a legislative change regarding terminations or access to the abortion pills, or does it have to be changed constitutionally? Do we have to repeal the 8th to allow this?
That most certainly is not a question for medical practitioners. Okay. That's a legal question. Okay. So we can't deal with that.
Okay. And the second question we have is regarding medical treatment while a woman is pregnant, if she finds herself in the unfortunate circumstances of having an illness or disease, possibly along the lines of cancer. Can she get any treatment that she wishes, or does she have to take into account the unborn baby, or can she just say for cancer just go and get chemotherapy and see what happens?
Well, thank you for the question. I just want one that comes on electronic chart, because on this Saturday coming, just for the Citizens Assembly, it's a new adventure for Ireland, an electronic chart, national chart for the entire country, and maternity services starts, launched in Cork on Saturday, and will be countrywide. It is the start of an electronic chart in every aspect of hospital care. So it's a massive change, but I would accept that as point. General practice, as in everything else, leads the way. I'm happy to surrender to that. No, I think that you've asked a question actually I've never considered, because I think what you said is, could a mother choose to have particularly, let's say, a chemotherapeutic agent that would be detrimental to the fetus? So, in terms of how, say, a mother with a malignancy would be treated, it would be certainly at the time of the diagnosis, depending on when in the pregnancy the diagnosis was made, it would be considered in the context of what we've been talking about. Is this a condition where, particularly if the pregnancy of itself might make matters worse, or is it possible to intervene to treat the cancer, and unfortunately the intervention leads to the termination of the pregnancy. So it would be considered in the way that we've considered the other two cases, but it doesn't have the same tremendous urgency, let's say, that the cases I've put forward have. Now, what happens in practice, because I think we're here to say what happens currently, is that because of an awfully, a much better understanding that has developed over the last 30, 40 years around chemotherapy and so on, an awful lot more options are now put to the mother. So it's got a lot more complex for us, actually. And interestingly, we probably are having a lot more pregnancies without an intervention in regard to delivery, because the mother has a cancer, because of an understanding about giving alternate options, tailoring doses, and in the past, for some cancers, we would have said, look, we need to intervene, and the intervention may involve surgery. The classic case in the past would have been cervical cancer, and that means a hysterectomy. And we did that, and that was part of the previous practice. Now what happens is that the mother has a lot of choices put to her, and is engaged in a complex discussion, in a balanced discussion. And it's certainly, since 2013 I haven't seen a case, but there would be cases that would come up where the option was a termination, for instance, and then a form of treatment. I've never come across a case where a mother has asked, and this just doesn't happen, so I don't know how you can put it. I've never seen a case where a mother has asked for treatment which she feels is inherently damaging to the fetus. What happens more commonly is that they discuss with the oncology team a range of treatment options. What's outlined to her is what would happen if she wasn't pregnant, what the usual phasing of treatment would be, and how you might manage this in pregnancy, depending on where she is, in many weeks. And it's a negotiated outcome. In every case I've seen it's a negotiated outcome. We do have a mechanism if termination was part of that, part of the decisions that were made. Yes, it's there under the Act. But I suppose what I'm trying to explain is it's quite complicated, it's quite nuanced, and the mother and her views are now very much central to what actually happens thereafter.
Yeah. I want to Professor McCarthy, want to say anything on that? Yeah. Thank you very much. Thank you very much.
Hi, I'm the facilitator for Table 14, and there were concerns at our table with regard to the status of the unborn, and I'm conscious that we asked John Higgins about this, and he was very generous in his information with it. But we'd like to hear just from the rest of the panel on whether or not they would welcome or think there's a need for extra legislation regarding the status of the unborn in terms of clarifying what exactly that means. And we had another question with regard to the HSE and people of limited means, in terms of it is obviously very expensive for somebody to go abroad to the UK or the Netherlands to actually get an abortion should they feel the need to do that. And I suppose we were wondering whether there were concerns as to, is money an issue where they feel there's a gap in that, and could there be any improvements going forward with that? Thanks.
Well, I think the first question, in fairness, is contrary to the rule we have set down for today. So that can't be dealt with today, but it will have to be dealt with on another occasion. So we'll move on to the second question, and maybe it's a question. Yes.
Just purely in terms of the psychiatry side of things, certainly the question of the status of the unborn within that context is almost irrelevant. Obviously, from an obstetric point of view, and if the baby's at 21, 22, 23 weeks and could possibly survive, then it becomes a very important issue, of course. But in dealing with the question of suicide, we're always dealing with, irrespective of what stage of the pregnancy is at, unless if the baby is, if it's not an issue that it's too late, that obviously the baby is going to survive. Then the status is to a certain extent irrelevant, because if that mother is going to kill herself, she and that unborn of whatever status is going to die together, and that's the issue for us.
Thank you very much, Professor McCarthy. Yeah. Oh yes, and then we move on to the second question.
I mean, the issue I suppose I presented as well was that women of higher earning power are more likely to travel for a termination, and I suppose that's for very practical reasons. In the cost of travelling, the cost of the termination, the cost of the airline ticket, accommodation if required. So there certainly is a reality there that the access to travelling to the UK for a termination is easier with greater financial means, and that really is just the reality of it.
Does that answer the question? Very good, thank you.
Good afternoon. This question is for Professor Higgins. Just in your paper, you mentioned that 3 terminations arose pursuant to Section 9 of the 2013 Act. So the table would interpret that as 3 applicants being successful in that application. The first question the table would be interested to know is, are you aware of how many applicants existed in the last 2 years in respect to Section 9 of the Act? And the second question arising from that would be, are you aware of the profile of those applicants? For example, I think we touched on it earlier on, were they people who couldn't travel by virtue of their immigration status? Were they incarcerated, or were they suffering from a disability?
Professor McCarthy had said there were 7. I mean, the data I've given you there was 3 in each year. That was 6 in total in 14 and 15. That's the data reported. I would have presumed that there were cases that had a termination under the Act. I don't think I know, but Anthony, you may actually know the answer to that.
No, there's no data on women who, for example, who have presented in any particular circumstance saying they're suicidal in pregnancy and either have seen a doctor, a psychiatrist or an obstetrician and not gone on to actually seek a second opinion, or we've no information on that. The only information we have is on, number 1, how many did have terminations because of mental health problems and suicidal risk. And secondly, how many were unhappy with the first assessment by 2 psychiatrists. So over just over 2 years of figures that we have, there were 3 terminations in each year. One of those was after a successful appeal, and it had been turned down by the first 2 psychiatrists and our obstetrician. We don't know which one or which 2 of those turned it down. And on appeal, she did have a termination, and there was one who went to appeal, and the appeal did not again think that her case fulfilled the criteria. We've no other information over and beyond that. With regards to the profile, the age, I certainly have no access to that. I sought it from the Department of Health, but I wasn't given that information.
Thank you. And just in terms of the appeal process, approximately how long does that take? Because the table has a concern that it could defeat the purpose of an actual appeal due to the gestation period.
The instructions are that it has to occur within 7 days. So if somebody wants an appeal, that has to go in writing. Within the appeal panel must convene and see her within 7 days.
And then just one very short question for Dr. O'Shea, just in terms of when a person presents himself at the GP service and a GP may refer a patient onto a counselling service. Is it an obligation of a GP, if they so decide to refer a person onto a counselling service, that they show a full list of all such counselling services, or do they have a discretion to pick and choose which counselling services they might refer a patient to?
I think in practice it's open to them to pick and choose, but in our training and in our educational process we recommend that they particularly refer to state agencies and the Crisis Pregnancy Agency. We refer in our own training material to www.positiveoptions.ie is the practice that we promote and the standard that we recommend.
Thank you very much.
Let's make a comment on the, just to come back to the first point that you made about the profile of the women, because it did strike me that when you're thinking about these small numbers, it's important to remember that now who are on treatment, which is another issue, some of whom are suicidal. We have a lot of patients who, over the course of pregnancy, are admitted to hospital. We sometimes admit them now. They're sometimes admitted to a psychiatric unit and so on. So I think you've got to put those numbers in the context of a big number of women who have depression and a range of severity. The other thing I think is important for the People's Assembly, when we were talking about charts and being modern in our charts, one of the things we're not modern about is perinatal psychiatry. So we have one of a very, very rare breed sitting to my right. He's like a rare bird. We don't have them, and it's a huge issue. And it's not so much for this debate, but it's very pertinent to the debate. It's for the generality of the women who are a large number with depression, suicide. But in these very, very difficult cases where you've heard all that has to be defined before you would fulfill the criteria, you need very, very specialist resources around the whole country, not just in Dublin, around the whole country, and they're not there.
Yeah. Are you saying that you need psychiatrists associated to maternity hospitals? Is that what you're saying?
It's very much part of the national strategy. It's a huge gap in our resources, psychiatry, counselling, clinical psychology. We don't have any of those services. It does make it very hard if you read and people have asked me as we've gone around about what that means, it makes it very hard to fulfill the act if you don't have the kind of specialist advice which you need. And I think, Anthony may have something on that. But.
I obviously wholeheartedly agree with that. I didn't want to bring up the particular issue of what seems like a narrow sectional interest just for us as psychiatrists, but actually based in maternity hospitals with a specific employment with a specific task to address perinatal psychiatry, there are 3 consultant psychiatrists in the country. I'm in Holles Street, there's a colleague in the Rotunda, a colleague in the Coombe. That's not to say there's no psychiatric service attached to the maternity hospital. So there's a liaison psychiatrist in Cork who's dealing with every medical specialty and who will also cover issues in the obstetric unit, but doesn't have a specialist screening clinic beforehand. So, for example, he will see, the psychiatrist in Cork may see people on an emergency assessment. It may be routine. In Hollow Street, we're seeing 700 women a year with mental health problems in pregnancy. That's because there's a specialist service there. There's nothing like that in any other unit around the country. There's some units in the country where they may have a nurse, a psychiatrically trained nurse, who will do assessments there, but there'll be no consultant psychiatrist attached to that. And the legislation, aware of that, has specifically said that, is limited in the requirements of who those psychiatrists should be who see the women. All it says is that the psychiatrist should have treated a woman in pregnancy. So they could have seen one woman in pregnancy before, and not be a routine part of their practice. Obviously, all psychiatrists are assessing suicide all of the time, every day of the week. That's part of our work. But the specific circumstances of pregnancy and these particular circumstances do require experienced people, experienced with the issues, experienced the issues of fetal viability, experienced of the other changes and other aspects, and the complex picture of relationships in pregnancy as well. So yes, it's a huge deficit. And if there was to be one recommendation which is way beyond the constitutional issues which you're here to address, but outside of that, does this country need specialist perinatal psychiatrists attached to every obstetric unit in the country? Of course it does.
As facilitator of Table 12, there's two questions. Number one, how often does the crisis pregnancy programme find that it comes into conflict with the current legal restrictions? And what is the most common cause of that conflict? And number two, the table was aware of women travelling to England for abortions, but was surprised at the mention of the Netherlands. Can anyone explain the incentive for travelling to that jurisdiction?
That's interesting. Janice, are you happy to answer the first question? Have you any difficulty with that?
I mean, I suppose the counselling services funded by the HSC, they work within the current legislation, and really that's as much as I can say about how it impacts on the services that we fund and the individual counsellors. They're very aware of the legislation. It's an area that is enshrined in legislation, so they have to be trained and cognizant, I suppose, of the legislative requirements in terms of providing information on abortion services abroad. In terms of your second question on the Netherlands, I believe in the past it may have been easier to access abortion services in the Netherlands if people had different means of travel, and it became a destination, I suppose, in terms of abortion services that reached out perhaps to Irish women in terms of the availability of services, but those numbers have dropped significantly. Provided we can see, I think maybe 15 women were seen to travel to the Netherlands in 2015. So really, the UK is the most common destination for women to travel to.
Hi. Table number 2. Of the proportion of those that travel for abortions, what percentage suffer from depression post-termination? And are you aware of any post-termination treatment, counselling for these women? And the second question is, in relation to crisis pregnancies, the figure of 1% on adoption, is there a figure in relation to foster care?
I mean, I might answer the second question first in terms of adoption. I'm not aware in terms of foster care whether there's a percentage in terms of a decision taken post a crisis pregnancy. I mean, the numbers of adoptions, as I said, are very low. And really, it's put forward as an option if the woman seeks information on it. There are certainly specialist adoption agencies, the Adoption Authority of Ireland, specialist social workers that would work with women should they seek that option, but it doesn't seem to be an option that women are seeking in great numbers, and really the numbers of domestic infant adoptions reflect that. I don't know in terms of the numbers of domestic infant foster caring. I don't have those statistics. I think the first question, perhaps Anthony might have more information on that.
With regards to the first, there's no specific Irish research on that. That hasn't been carried out. Research worldwide is controversial, and Irish, we are a very specific culture, so there may be differences here. The overall picture that comes across, and there's not consensus on this, but the overall assessment is that for the majority of women after termination of pregnancy, there's no major long-term mental health problems. That there are particularly vulnerable groups, and the vulnerable groups are those who have a history of depression before. So if they have a significant history of depression in other circumstances, or major mental health problems, the assessment, certainly at the time they're seeking that termination, really needs to be aware of that. Because, for example, if I have someone who's profound guilt, has an obsessional guilt about everything, and always blames themselves for everything, we know that's a particularly vulnerable person. So we need to be cognizant of that, and certainly in any assessment that would be the case. But we know those are major mental health problems. That potential damage to them of the termination, even if that's what they want, that has to be weighed up in a clinical way. That's the first factor. The other is that consistently across the world, women who are either put under huge pressure to have a termination, or women who are put under huge pressure not to have a termination, they are much more likely to have significant mental health problems afterwards because of that. That's what comes across.
Would anybody else like to say something on that post? Yeah.
You've raised a very important question in terms of what services are available for people who are experiencing these difficulties. In general practice, because it's general practice, we do quite a lot of things, but we would estimate that probably about 1 in 3 of our consults, and we have north of 24 million consults a year, have a significant mental health element to it. The majority of psychiatry that's practiced in our health system is actually practiced by general practitioners and practice nurses. The more severe end of the spectrum goes into secondary care psychiatry or community psychiatry. Part of what we do is that we are quickly and easily available for people who are experiencing significant mental health issues, and certainly we see this in practice. But Anthony's made a very eloquent and proper case for the need for more perinatal psychiatry. There is a strong, compelling case for more general practitioners, and I won't bore you with that, but the need is there. So we would hope that people do have access to primary care support where it's necessary.
Thank you. I'm the facilitator for Table 10, and we have 2 questions. First of all, I think perhaps for Professor Higgins, we had some clarification again, just in relation to the terminations and the differences in terminations between sections 7, 8 and 9 of the 2013 Act. And the second question, which is probably more direct at Janice, is in a crisis pregnancy situation, what is the current practice and experience in relation to the rights and the role of the father? Thank you.
Okay. Again, if I get this wrong, there are enough lawyers here to correct me, which they're always wanting to do, I can assure you. But in simple terms, obstetric terms, the 3 sections, the only sections of the Act that really are very pertinent to us are 7, 8 and 9. So 7 is where you have the mother's life is in danger, really, from a physical problem. So the first 2 cases I put up were cases, one was infection, the other was severe preeclampsia. Both of those are section 7, and 2 practitioners, one of whom has to be an obstetrician, but in practical terms, except maybe the case we were talking about, say a cancer case, you're really talking about 2 obstetricians usually, who would have to confirm that it fulfills the criteria of the Act, and that the only reasonable intervention to save the mother's life is to do a termination. So that's section 7. Section 8, I mentioned it, I don't know what group I was at. Section 8 would be the first case we mentioned, with the woman's in septic shock at 2:30 on a Sunday morning. That's kind of the middle of the weekend. That's the world the obstetricians live in, and that happens. And the Act is clear that if you've got an immediate risk, where you need to intervene, then one person can make that decision. You don't need the second consultant. And of course, it would be difficult sometimes, just in practical terms, to get a second person in a smaller unit. Someone made that point to me. If you say a unit with 3 obstetricians and it's a weekend, there may only be one in the actual town physically available. So that's where you have an immediate situation. That's 8, section 8. It's the same kind of disorder, but it's more immediate, and one person is going to make the decision. And then the section 9 is the one that Professor McCarthy is talking about, which is where the risk is not physical. And I suppose what I said in my own talk was I don't like separating the cases like that, but the same scenario arises. There's a substantial risk to the mother's life. It is focused on pregnancy, because suicide could be something else entirely. And as Professor McCarthy said, then you need, I suppose, to be also convinced that the termination is the only reasonable thing to do to save the mother's life. And that is more complicated. It's more uncommon than what we would be dealing with. You saw the numbers, 3 out of 25, so it's a minority. And it requires 2 psychiatrists, one of whom is attached to a maternity hospital, and an obstetrician. So it is more complicated. So there are the 3 parts. 7 is the broad generality problem. 8 is where it's urgent. Those 2 areas we've been working on for years. The Act hasn't really changed it very much. Suicide is section 9, which is new. Is that okay?
Yeah, that's
Judge, did I say anything?
No, you got it right. I mean, section 8 is an emergency scenario. Yeah.
And I suppose then, in terms of the role of the father, I suppose it is recognised by the funded crisis pregnancy counselling services that the father is there in terms of somebody who may need support, either with his partner around crisis pregnancy counselling or separate to his partner. And they can equally access free crisis pregnancy counselling through all of the funded services. So absolutely the role of the father is recognised, and it's acknowledged that he also needs support around a crisis pregnancy.
I'm the facilitator at table 13. The question is for Professor Higgins. In case number 1, would the same procedure be followed at 25 weeks as it would be at 18?
Okay, I mean, one of the questions I was asked at every, in fact, the question was asked at every table, I think, was along the same lines actually, almost everyone asked it, which was this question about viability and its importance in thinking about these cases. I might just repeat the answer we gave, which was that somewhere between 23 to 24 weeks, we now start to have babies being born alive who survive. And that timeline is slowly moving down the way as our neonatal specialisation and expertise has been improving. So it is different if you're making the decision. If you went, I think, use case 2, if I don't mind me asking, use case 2 for a second. It is different when you're considering that decision if you are at 16 weeks or 17, 18 weeks, let's say, with severe early onset atypical preeclampsia in your thinking. You may be able to wait a few days. You won't at 17 or 18 weeks once you've made the diagnosis. There's no benefit because you're way below viability. At 25 weeks, in that second case, the preeclampsia, if you thought you might get a few extra days, you definitely want them. Every day counts in terms of the long-term outcome for the baby that's about to be delivered. Difference between long-term disability, perhaps, and almost normal life. It's huge. So you want extra time. But the case you've chosen is case number 1. And that is different. Again, that's why I say you can't have a rule for everything. Case number 1, they've now got established chorioamnitis. The mother is in septic shock. And really, that's one where we think, if we don't do something now, how quickly are we moving? Because this is something now, look, I've seen a couple of these cases in the last few weeks. This is something that you're going to do something now. You want the mother move down to the labour ward now. You want them to start the process of trying to get the baby delivered now. And it really doesn't matter in that scenario because there's such an urgency, and we don't alter our treatment, whether it's 18, 19, 24, 25 or 32 weeks. The treatment is the same. The treatment is the same. So the conditions are different, and you've picked in chorioamnitis, or I've picked as an example, a case where once it's there, it's very clear, regardless of gestation, you must deliver. That's always been our practice. And sometimes in the reporting over the last few years, you mightn't have picked up on that. But in Ireland, we always practice in that way, and in every country practice in that way.
Hi, I'm the facilitator for Table 9. I have a question directed for Professor Higgins because it arose out of a discussion of his scenarios, but it's quite a general question. The table was concerned that do you and your colleagues face cases, difficult cases that come in, which you know from your experience, your knowledge, are going to end in induced delivery, but because of the state of the current law, does that cause you to delay your intervention until that illness has progressed to a certain stage of threat against the mother? I think that possibly the fundamental question is, would your intervention be quicker, medically indicated be quicker, were the current law not as it is now?
That came up the question came up a couple of times and going around. We're going back to case 1, I think, because it's very pertinent. I know people are very focused on that case. In other countries, what would happen in the discussion? There would often be a discussion that involves the ruptured membranes, outlining the long-term possible sequelae, even if the pregnancy goes very far and towards the end, what effect it could have, and so on. If you get infected, we need to deliver you with great urgency. But it would be fair to say in other countries the option would be there of a termination. They might just say, okay, thank you, and it would be discussed. So we wouldn't, and this is our practice, we wouldn't do a termination at that stage. I'd have to say that in other countries, many women wouldn't have a termination at that stage either, because they don't know whether they're going to be there awaiting an infection to arise. They don't know if they're going to be there for 2 weeks or if they're going to be there for 4 months and deliver a baby that will do very well indeed. So there's a lot of variability. It's hard to predict, and we can't predict. And in our situation, I suppose the one thing we wouldn't do is we wouldn't do a termination just because the membranes were ruptured, because of a potential risk. And we do wait until we have some signs of chorioamnitis. Now that practice would be very common everywhere in the developed world. But in our case, we don't there isn't a choice there just at the very start to say, or for the mother to say, I've looked at all those options and I want a termination now. That isn't there at the moment.
But is there a case where you or your colleagues know that there is no possibility of a healthy delivery, but where you still delay in an intervention until a certain level of threat against the life of the mother has been reached?
No. So there's, in this case, there is a lot of uncertainty starting out about when we would, or if we would, because we almost always do end up having to do something in those cases, but it's when. It's when. And we're not sure about that. Where these cases cause us other difficulties, practical difficulties, are when the onset of infection is associated, as it very often is, with the onset of spontaneous labour. So we don't have to do anything because it's resolving. And the mother is at that critical threshold, which we're not sure where it should be, 23, 24, 25 weeks. And it does cause us real it causes us to make a lot of hard decisions around how we're going to monitor this unborn baby? Do we intervene? Do we not intervene? Given the likelihood of a bad outcome after the baby is born. So it's complicated right to the very end. The best outcomes in these cases happen if nothing happens until you get further in the pregnancy. Maybe you get to 32 weeks, 33 weeks. And then the mother gets chorioamnitis or labour or both together, and you're expecting a much better outcome. Even then there's some doubt. Even then there may be damage because the fetus has had no fluid around it.
Is that then the answer that Sections 7 and 8 don't inhibit medical practice and that you would do as you do otherwise?
They don't inhibit what we would normally do, no. In fact, they probably, the benefit of them may be, to me anyway, that they provide some reassurance to some clinicians who would have been uncomfortable around not having a legal framework. I wouldn't have put myself in that group of clinicians who felt I needed legislation around the Constitution. Many obstetricians were happy enough to practice based on the medical issues in front of them. Others felt they needed a legal framework, and they certainly feel more comfortable about intervening. It's the opposite to your hypothesis, because they had a legal framework.
Very good, thank you.
I just have a few questions on behalf of Table 7. Just the first question, is there any research or are there any known health risks to illegal abortifacient medications? And then in relation to, just corollary to what Table 11 asked, GPs in Ireland, would they have any access to medical records from the UK clinics in respect of their own patients who have travelled for abortions and have come back then? And then finally, third question, in relation to doctors who have a conscientious objection, have there ever been any cases in which they simply couldn't bring themselves to give a list of other doctors, or are they even required to have leaflets in their clinics setting out a full list of available options, not necessarily to talk about them? So yeah, there are the questions.
If just responding in reverse order, doctors who have conscientious objections to engaging in conversations or providing any information, there is a very clear code of practice elaborated. It's elaborated certainly through the ICGP in our training materials, but there isn't, as far as I'm aware, an absolute legal requirement. And I don't believe that, I don't know of any practices that, or any GP that would have a list of alternative colleagues displayed. In terms of your second question, do Irish GPs have access to medical records of their patients who have been treated in UK clinics? In practical terms, the likelihood where that would be medically necessary would be extremely unusual. I would think that in practice it would be possible to obtain records, either for the woman herself to obtain the records directly, or if a contact was made between a GP surgery or a GP in Ireland and a UK clinic, I would anticipate it would be possible to obtain a copy of the medical records, but I am speculating about it and I don't have proof of that, but I believe it wouldn't be a practical material issue. With respect to your first question, which relates to the side effects of chemical abortifacients, I think it is important to understand that in other health systems, in other jurisdictions, the use of chemical abortifacients it's a larger scale activity. These agents have been available and used by significant and increasing and large numbers of individuals during the last 1.5 to 2 decades. They are considered to be relatively quite safe. They do have side effects. For the most part, the side effects are transient and minor in nature. And if you particularly do a risk-benefit analysis in a clinical sense and compare the relative complications or risk of a surgical termination or the lifetime risk arising from unplanned pregnancy, and compare it with the risk the medical risk from using an abortifacient such as RU456, there's very little comparison. That the use of an agent like RU456 is relatively tiny by comparison. So summarising that, really, they are known to be relatively very safe, and particularly when they're used in an appropriate manner according to the licensing instructions. But I would emphasise that we do not have legal permission to disseminate information in relation to this as Irish Channel practitioners under the current law.
If I could just take up the question of the responsibility of the doctors who have moral objections to dealing with this. There is clear guidance in the Medical Council for all doctors in all areas of our practice, and it's also reiterated in the guidance document with regards to 2013 Act, that if any patient presents to us with a medical and or psychiatric issue, and we have some conscientious objection to dealing with the issue, we can't just then ignore the patient, and we are responsible for that patient until we ensure that an alternative doctor is available to them. And this has never been tested in law as far as I'm aware, and I don't know that doctors having lists of other doctors to be available, but we are responsible for any patient who comes to see us. So in the case of suicide, if somebody came to see us in pregnancy and they were suicidal, even if I don't want to deal with that, and many doctors don't, it is still their responsibility to ensure that person then has access to another doctor who is prepared to see them.
I just want to say one thing. I think we'll have to give consideration, and I've been thinking about this for some time, to what is available in terms of guidelines, such as the Medical Council guidelines, the Code of Practice of the Irish College of Practitioners. I think the Royal College of Surgeons has guidelines as well. I think I read that somewhere. But anyway, we will look into that, and so that we're in a position to inform you before perhaps the next meeting. But I just think it's important. If there are guidelines there by regulatory bodies, I think we should be aware of them. So that's something that it has been on my mind. We've gone past 5:15. Will we stop there, or is? I take it everybody's going to put up their hands and say yes. Is that right? This has been a most valuable afternoon, absolutely. And I think sisters and colleagues, would you agree? It's been a very I'm very grateful to our four speakers for really an informative afternoon, and it is going to help our deliberations down the road. And we've had a long day. We've all been concentrating for a long time, and we'll call it a day now, and we'll go and relax for a while and have a good evening. Thank you very much.
Thank you.